This writ petition fails and is dismissed.
Lordship.
Item number 2,
Oh, sorry, go in Mira. I will order to so No, this is judgment. Dismissed. Itu juga sesuatu. Copy এটা লাগিয়ে দিল বাবা পরিমাণ অ্যাক্টিভেশন নিয়ে কপি এটা লাগিয়ে দিল আইটা অর্ডার তো সরি আছে নাকি
item 3 for pronouncement of judgmental order.
dismissed. Much obliged. Copy এটা লাগিয়ে দিল
Wait, please, Lordship. This matter, small matter, Lordship.
সই কপি আছে রেকর্ড আছে না এটা অর্ডার সই কপি আছে রেকর্ড আছে ইয়াত না রেকর্ড আছে পড়ি যায় অর্ডার চেক কৰি ল'ব লাগিব চেক কৰি
Wait, please, Lordship. Small matter, Lordship. For correction of the order passed by your Lordship. Let the matter be listed on 11th. Correction of clerical mistake.
not 11th not on 11th
11th, Lordship.
16th any urgency
Small correction of the order.
but it's not very urgent no is it very urgent
We have to take
Can
steps.
wait, no?
Unless and otherwise the order is corrected, we cannot take steps.
সব অকমান আগত দিব পাৰি নেকি
Let it be on 11th.
10th on 10th
10th, Lordship.
My lord, I beg to mention item number 15 of court number 14.
Court number 15 item number 15
Of court number 14, this matter may be listed on 11th, my lord, because this.
item number 15 of court number 14
Court number 14. We didn't mention, no? Permission to know. So
Okay.
it may be, I'll fill up the
Yes,
mention
yes.
memo.
yes
It may come up on 11th because the petitioner is suffering from serious illness and matter is pending for the last 5 years.
It is the order to move on the morning.
May it please your lordship, I beg to mention item number 12. I am for the appellant. I have taken the consent of the respondent side. Let the matter may come after vacation, my lord.
The council miss
Yes, Roy.
S.
Roy.
Roy, with the consent of the other side, has prayed for adjournment, list this matter after vacation.
Not of.
May I please, Your Lordship? May I pray for listing of a CRPIO, Lordship? The trial court is proceeding with the matter. We have challenged an order under Order 7 Rule 11 on the ground of the suit is barred by law of limitation. So that is rejected. We filed a CRPIO that is notice has been issued and it may be fixed for admission, Lordship. On the suit is fixed on 18. So prior to 18, Lordship, any day,
15 for about 16 on 16.
Lordship.
Much obliged.
May I please, your lordship, with the consent of respondent, I beg to mention item number 20, hearing column, lordship. It are currently adjourned for today, lordship. It's after vacation.
Learned council Mr.
P. Sharma.
P. Sharma,
Yes, lordship.
with the consent of the other side, has prayed for adjournment, list the matter after puja vacation.
After puja, part 2 hearing this, lordship. Hearing matter.
What?
Part 2 hearing this, lordship. If possible,
Part.
daily list, yes. Yes, after puja vacation. Okay.
May I please, Lord. I wish to mention one IA for listing, my lord. In this case, in an MSA appeal, the 50% amount has been deposited before the
You want to
registry,
withdraw?
lordship.
Okay.
All right.
Please, your lordship. With the consent of other side, I beg to mention item number 5, your lordship. Kindly grant me it generally for a week, your lordship.
Learned council Mr.
As Gautam for the petitioner, your lordship.
S. Gautam,
For the applicant, your lordship,
As Gautam, for the applicant with the consent of the other side has prayed for adjournment, list the matter. When do you want?
lordship, next week's 17th or 16th. 17th. Oblige, your lordship.
Your lordship, I would like to mention one RSA matter for listing. Your lordship, please allow before puja vacation. 18. Your lordship,
Motion
one.
stage,
Yes,
at
lordship.
motion stage.
No, your lordship, at orders.
Orders.
It was last listed on 15/11/2023. And one.
Orders of আছে পাৰি হেৰি last week তো দিব পাৰি motion stage তো দিব পাৰি
Before.
23rd September.
And your lordship, one RFA matter, same, it was last listed on 5/6/2025.
18 কৰি দিব
Highly request.
Please, your lordship. Lordship, I beg to mention item number 4 of court number 14. It's a RSA matter.
court number 14 list ক'ত মই দেখা নাই
Tomorrow, day after tomorrow, any day. 11, man.
May I please, your lordship? Ma'am, two NDPS are to be listed.
MFA
Yeah, ma'am.
after vacation
Okay, ma'am.
list খন দিয়া নাই মোক
May I please, your lordship? Your lordship, I beg to mention one CRP for listing lordship in
এইটো
admission. for-
deferred আছে না কোৰ্টত পাৰিব yes yes
I beg to mention one CRP for listing in admission column lordship. Can it be on Thursday lordship?
Thursday পাই নেকি admission 18 September
Bless.
May I please, your lordship, for listing of RSA matter, which was last listed on 20th of July 2025.
sir court list কৰিব পাৰি
20 July.
pending at which stage hearing
Yes,
hearing stage
yes.
up to puja vacation
The matter is urgent. As we are the appellants, the other side has filed an execution title, so we need a stay for that.
14th October
Your lordship, may
তাৰ আগত দি দিয়া পুজা vacation আগত দি দিয়া
before puja vacation.
15 September item 1
Lordship, this is listed for mediation referral, but
এইটো
this
শেষ
is
হৈ গ'ল
not. This is listed for mediation referral, but this is not a fit case for mediation, lordship, because pay and recovery is given, we have come against that. And otherwise, it is a delay petition, lordship. And the office note shows, office note dated 5/9/25 shows that no AD card and unserved notice have been received from respondent 2 and 3. So we have to await service report.
My lord, I would like to file my objections to the delay petition, my lord. My lord, just to point out something, my lord.
it will come up in the normally it will come
Normally, my
they'll
my lord.
come up in the usual course
My lord,
learned counsel Miss R.D. Muzumdar heard learned counsel Miss R.D. Muzumdar who has submitted that There is no element of settlement in this matter and the matter may not be referred for mediation. Heard Mr. A.B. Dev, Learned Counsel Correspondent number 1, full stop. List this matter after puja vacation.
My lord, if it can be listed before, that will be also.
Your Lordship, service report will be required because owner is required in the case. I think.
A date may be fixed, my lord, a date.
Date that during puja
I don't
vacation.
mind date.
List this matter on 16th October.
Oblige, my lord.
Highly obliged, Lordship.
Lordship, I am product caveator, Lordship. I beg to pray for an adjournment, Lordship, because my senior is in hospital last night.
Okay.
So,
Okay.
can it be on after puja vacation, Lordship?
Can be after puja vacation? Can it be after puja vacation?
Yes.
Yes. Learned Counsel Mr.
S.J. Rajbangshi.
S.
J. Rajbangshi.
J. Rajbangshi has submitted that his senior learned counsel
An alum.
N. Alam
Yes.
is indisposed today. Learned Counsel Mr.
M. Bedia, Your Lordship, I am appearing on behalf of N. Jha.
M.
Bedia.
Beria on behalf of Learned Counsel Mr. N. Jha is present for the appellants. List the matter after puja vacation.
Okay. Highly obliged.
May I please, Lordship, kindly pass over the matter for time being. Senior Engaged Counsel Sanadapur.
Item 3. Item 3.
May I please, Your Lordship? Lordship, today, IA 483 of 2018 is before Your Lordship for condonation of delay. There is a delay of 64 days in filing the regular part appeal before the Honorable Court. So where the present appellant.
Do you have any objection?
Yes, my lord, I have filed my objection, my lord.
IA number?
483 of 2018,
How many days delay?
64 days of delay. May I submit one thing, my lord? In their objection against the delay condonation
It is your
petition,
case.
Yes.
Go to the objection later.
Yes,
This is
yes.
your case.
there's a delay of 64 days. Lordship will find the explanation in para 5(6). I have annexed the medical documents also. Due to the said reason, my lord, Lordship may kindly see the para 5 and 6 of my petition.
Yes, where is your objection?
I have filed objection, my lord, that
From page number 24, continuing, Lordship.
Objection?
Their objection in page number 24 of the minutes question. May I submit one thing, Lordship?
Yes.
Uh,
No, let him submit on the objection. Let him submit.
Okay.
Yes.
my lord, I have stated in my paragraph 5 and 6, and my lord, apart from that, my lord, in this case, the order is under challenge is the preliminary decree, my lord. And the order under challenge is the preliminary decree, my lord. And thereafter, my lord, on 29/11/2018, already, my lord, final decree was passed. And that is not challenged till now, my lord. And my lord, the explanation that is given is not sufficient, my lord.
Explanation is sufficient, but without objection, without any appeal against final decree, why you are preferring appeal against only preliminary decree?
My lord, we preferred this appeal immediately after passing of the preliminary decree in the 2000, but there is a delay. That's why the matter is pending till then. The thing is that, my lord, when they filed their objection against the delay condonation petition, they informed this honorable court that the final decree is passed. So, and they filed this objection on lordship. For a moment, if your lordship peruse, page number 30 of their objection on 5th of March 2025. 5th of March 2025, they filed their objection, informing this honorable court that in this case, final decree has already passed. And for a moment, if your lordship peruse, page number 25, this is para 1 of their objection. It is stated that I am the respondent number 2 in the aforesaid IA so-and-so, and as such, fully convergent of facts and circumstances of the case, and also authorized by the respondent number 1 to swear this affidavit on her behalf. The present appeal is filed by the son, the appellant, and the opposite party is the mother and his own sister. So mother is the opposite party number 1, and the sister is the opposite party number 2. Against this objection, we file a reply also. It is on record, my lord. If your lordship peruse the reply, lordship will find that we annex.
Which are the relevant paragraphs of your objection?
My lord, paragraph 5, my lord.
What I am planning to submit before this honorable court is that the mother already expired in the year 2021. In 2025, they filed the affidavit stating that the respondent number 2 is authorized by respondent number 1. In fact, in presence of the council, this honorable court, lordship may kindly see the IA.
But that is a
Lordship may kindly see.
error, my lord.
That cannot be. That cannot be. Why I am saying that, lordship? In Annexer A, page number 8 of my IA 2933, I have annexed the order passed by this honorable court. It is here, it is mentioned that here in this case, the respondent Srimati Premalata Phaikya has expired and respondent number 2 is her only daughter. There are no other legal heirs of late Premalata Phaikya. Therefore, the name of Premalata Phaikya shall be strike off from the title page of the application. This is the order passed by this honorable court on 15th of May 2024. And they filed their affidavit in the month of March 2025, the daughter swearing that for herself and for her mother. Why I am submitting before this honorable court is that recently I came to know they, after expiry of the mother in the year 2021, the daughter filed a execution proceeding before the trial court, claiming 2/3 of the share. The preliminary decree was to directing the party to claim 2/3 of the share and 1/3 for me. I was against that and I approached this honorable court by way of a regular first appeal. The mother expired in the year 2021. The execution proceedings start in the year 2024. In the 24 itself, this honorable court struck off the name of the mother in presence of the council appearing on behalf of the parties. Thereafter, my lord, in the month of March 2025, they filed this objection against my delay condonation petition, stating that the mother is alive. And they are also praying for, my lord, 2/3 of the share of the land, whereas there are 3 legal heirs of the deceased father, mother, daughter, and the son. If mother expired, automatically it's a matter of merit. The thing is that, my lord, the delay condonation was 64 days, but in objection itself, they purposefully concealed some fact. They submitted their objection in the month of March 2025, knowing fully well that mother expired in the year 2021. I have annexed the certificate of a local Gaungura, village headman I have already annexed, my lord, in my reply petition against the objection filed by the opposite party in delay condonation petition. There is no negligence or lessons, my lord, for filing the regular first appeal. And my lord, my responsible submission is that if there is a something to interfere by this honorable court in the preliminary decree, then subsequently final decree will go. If there is something, if this honorable court finds something in the preliminary decree. madam. And we have a good case on merit, my lord. So 64 days of delay may be condoned, considering the statement made in paragraph number 5 and 6 of my RFA, regular first step.
Page 8 is the death certificate or medical report.
Medical report.
These are medical, but death certificate is in my reply against the affidavit filed by the, it is in annexure A, page number 45. Continuing case 45, madam. And in vernacular, it's 46. It is issued by the village headman, stating that on 15th of July 2021,
Learned Counsel, Mr. Your name,
PP Bothakur,
item number,
3, ma'am.
3.
PP Bothakur is present for the applicant. And Learned Counsel, Mr. A.K. Gupta, no,
Correct.
is present for the respondent, opposite parties. It IN number.
One opposite party.
Only
only now.
respondent
The
number
daughter
2,
is
madam.
there.
Other mother already expired, ma'am.
Yeah, yes. Okay. IN number 483, 2018. Right? 483, 2018.
Yes, 483.
Yes, opposite party number 2.
Yes. One already expired. 2 is now before the salon.
The respondent number 1 has passed away and her name has been struck off by the order dated 15/5/2024. Full stop. This application is filed under Section 5 of the Indian Limitation Act 1963 with prayer for continuation of delay of 64 days in referring the regular first appeal against the judgment and decree dated 18/7/2017 passed by the learned civil judge Jorhat in connection with title suit number 61/2015. It is submitted that the applicant's daughter, Srimati Priyanki Soikia, was suffering from menorrhagia, MENORRHAGIA, with severe anemia, ANEMIA, full stop. The applicant had to attend to his daughter, full stop. Thereafter, the applicant managed to obtain the certified copies of the of this case after the judgment on, it was passed on 18/7, no? 18/7/2017. And he came to Guwahati on 3/12/2017 to meet his engaged counsel, and he handed over all the relevant documents. The advocate called him on 4/12/2017 after verification of the documents, but suddenly the applicant's mother took ill. So she is the respondent number one.
No, my mother, my own mother.
Okay, okay,
She was hospitalized in Surat.
okay. The respondent's mother took ill.
Not
And-
engaged counsel's mother, this is my mother,
Okay.
Engaged conscious.
my mother.
Oh,
own-
your mother.
Yes.
Was, but suddenly the learned engaged counsel's mother took ill. And the engaged counsel had to leave for his native place at Johar to attend to his mother, who was hospitalized from 5/12/2017 to 8/12/2017. For proper care. Full stop. After recuperation, RECUPERATION, the learned engaged counsel returned to Guwahati on 19/12/2017. And it took him 5 days to prepare for the first appeal, but owing to the winter vacations from 24/12/2017 to 26/12/2017, there was a delay of 64 days in preparing the appeal. Full stop. Annexure A series are the documents relating to the ailment of Priyanki Soikia, whereas Annexure B series are the documents in support of the applicant's submission that in support of the applicant's to substantiate the applicant's submission. Full stop. The learned counsel for the opposite party number 2 filed a written objection. Filed a counter affidavit declaration of this, filed a counter affidavit. Which has been assailed by the learned counsel for the applicant through his reply, as the affidavit was filed on
Application. 27,
7/3/2025, and it was filed on behalf of both the opposite parties, the opposite party number 1 and the opposite party number 2, despite the fact that the opposite party number 2 has passed away in the meanwhile. Full stop. All right.
Yes.
In reply, it is submitted by the learned counsel for the opposite party number 2 that this is a typographical error. Clerical mistake. This is a clerical mistake. Full stop. The opposite party has refuted the statements, the reasons of the delay justified by the applicants, stating that the reasons are vague and false only to fill in the lacunae, LACUNE, to prepare excuses for coordination of delay, full stop. Malafide is discernible on the part of the applicants whose sufficient grounds have not been shown and the applicant ought to be rejected. Moreover, final decree has already been passed in connection with
Page 16.
title suit number
Title suit number, my lord, 61 of 2015.
61 of 2015, and this RFA is thus infructuous. To stop. I have considered the submissions at the bar with circumspection. I have scrutinized the documents substantiating the application. To stop. And I have also considered the submission that if the decision on the preliminary decree, that the decision on the preliminary decree is crucial crucial and has a bearing on the final decree, is crucial and has a bearing on the final decree. It appears that sufficient grounds have been shown to stop. No malafide is discernible on the part of the applicants. Considering all aspects, delay of 64 days is hereby condoned. Stop. Registry to register the connected RFA.
RFA is already numbered. It's 18 of 2018. Lordship, may kindly say it is already
Okay,
numbered.
okay.
It is already
Registry to
registered.
list the connected RFA. Number how much?
18 of 2018.
18 of 2018.
18. May I pray one thing, my lord?
Ends usual course. Ends usual course, not like after puja vacation.
A copy of the appeal memo may be served to me, ma'am.
Appellant to furnish copies of the appeal memo to the respondents.
May I submit one thing? As the case is already numbered, appeal is registered, so Lordship may kindly admit it today because they are already proceeding
No,
with the
no.
execution process. So we have.
No.
Then before
Is
puja
it-
vacation, my lord, I have some urgency. Because tomorrow is also the date for in execution proceeding court. So Lordship, that may be otherwise, if execution is completed, then everything will be in practice, my lord. Lordship, can you give some protection to me?
There's no RFA to dear. Let it come up because today we have condoned the delay. Let it come up. Then before puja vacation, we can fix a date.
For puja vacation, any date for admission hearing, my lord.
Yes. Before puja vacation date, dear.
19th September.
Date to DD.
That should always be.
No,
Timing at that.
I am not going to formulate any substantial question of law. I'm not going to formulate any substantial question of law.
Yeah.
Yes, that's why I have fixed it.
I have a submission before your lordship.
No, I have gone through.
PW
entire-
3, 4 and 2.
No, I have gone through entire records.
My lord.
You can, we can fix it for another date or before another court, or I'll pass an order. I am not going to formulate any.
Not
substantial-
another court, my lord, another date may be given.
Another date.
Least before. I'm not.
After vacation?
I'm not placing before your lordship that your lordship should not take it. I'm not playing that. It may be after vacation, my lord.
Does this matter before, list this matter after puja vacation?
Oblige, your lordship.
Item number 4 for others.
Your lordship. Well, this is an appeal against the granting of probate. The respondents have appeared. This.
Is it for admission or hearing?
Yes, let it come for admission, my.
Yes.
Learned Senior Counsel, Mr. M.K. Chaudhary is present for the, this is appeal or?
It's an appeal, but then it's my lord, registered as a interested case.
So it will be the applicant.
Yes, ma'am.
Applicant. And Learned Senior Counsel, Mr. G.N. Thayala is present for the respondent. So, Heribu ase na? List this matter for admission after butchification
Date may be fixed.
as readings are complete. List this matter for admission. We'll fix a date. Okay.
Yes, ma'am.
15th October.
Huh?
15th October.
15th October. Yes.
Obliged.
Item number 7.
May I please, your lordship? Lordship, I am appealing on behalf of Mr. B.K. Bhagwati. He is on his leg in another court. Matter may be passed over for the timing.
Timing. Okay. Okay. For the timing, yes.
Item number 8 for hearing.
Yes, I'm saying. Criminal hearing. কোনটো কেছ এইটো আজি কোনোৱে নাই গম পোৱা নাই নেকি এইটো ৰাখি থৈ দে বাৰে বাৰে আহি থাকে ৰাখি থৈ দিয়ে
Item number 9 for hearing.
For the appellant. I am for the appellant.
Actually, some old RSS have been listed these days. That is why one party is aware of the list and other party is not aware most of the time.
Yes, madam.
Last time, I think both the parties were present.
Present. For the time being, maybe, my lord. I will call for the time.
For the time being.
I will
All
call.
right.
I will call.
Time being, okay, ৰাখি থৈ দিব পাৰি.
Item 10.
This is an MSc appeal for enhancement of the award passed by learned member tribunal Bongaigaon, MHT Bongaigaon. Here, there is no dispute regarding the accident or anything, only on the amount. We have come up for enhancement on behalf of the claimant. The deceased was a practicing advocate within the district of Bongaigaon and our every courts. While passing the judgment, learned trial court has taken the income at ₹5,000 only. Whether our claim is of 25,000 income. Normally, the grounds taken that no income proof was given. For an advocate, it is almost impossible, lordship, to give an income certificate. He was a retired MLA. He was the president of the All Assam Coach Rajvanshi Shanmilani. And on the other ground, so we have paid for enhancement of that amount of income. At least should be taken 25,000.
Retired MLA will get this pension.
The pension is always not given by as a MLA. He is giving pension, no relation with the tort figures. Pension is a different matter. It cannot be deducted. I will rely upon one judgment.
But,
I also rely upon one judgment on that.
It will be deducted, but that income can be calculated on that
No.
grounds.
That is a different part. Income as an advocate, he is a standing practice of more than 20 years at the time of his death. So income has to be taken on that line. The judgment also taken the part of only this loss of consortium at 25,000 and 1 lakh was given towards loss of consortium. No amount was given towards love and affection. At that time, Rajesh versus Rajbir was the law.
Yes, yes.
Tribunal has also taken that part.
Calculated according to the earlier judgment.
So
2015.
yes, another should have been amount of ₹1 lakh towards love and affection. Rajesh versus Rajbir, it is 2.5 lakhs. 1 lakh towards consortium, 1 lakh towards love and affection, and 25,000 towards funeral assistance. And this judgment, lordship, interest has been given at the rate of 6% per annum from the date of passing judgment till realization. In MSCT, it should be from the date of claim. Claim is of 2008. after completion of the process of appearance, WS, etc., we have given our
Actually,
evidence in
depends.
2011.
Yeah, depends, because if you are delaying.
No, we have given our 11 on 2011, Lordship. This judgment was passed in 2015. There was no delay analysis in our part. So on these simple grounds, we have come up for enhancement, Lordship.
Do you have the judgments with you?
Yes, Lord.
Supporting judgment?
Yes, Lordship. So for family pension non-deductible, I am relying upon this judgment of Rekha Bayan of our Honorable Guwahati High Court, Lordship. I am giving, I am this one. For income of an advocate, I am relying upon two judgments, Lordship. One of Honorable Supreme Court of India. The case involved determination of compensation following the death of an advocate. Our Honorable Guwahati High Court in the case of United India Insurance, it is also a death of advocate. And so for interest part is concerned, also, I am relying on two judgments. I could not take only on website certificate copy is there. And from the date of petition regarding, I am relying on these two judgments. Lordship.
This last one is for what? These two, death of an advocate.
Lordship.
Previously have sent two judgments on death of
Death of
advocate.
advocate, Lordship. So income has been taken on 25,000, in one case 20,000.
And
It is
this
purely an assumption.
this
And two
judgment,
on interest part, Lordship.
Kajal
Kajal-
is that
Interest part is there, Lordship covered.
Kajal is that famous judgment, I forgot for what.
Kajal
It's a
was for
famous
the
judgment.
interest from the date of petition.
Oh, interest from the
Interest from the date of petition. In that case, interest rate was shown as 7.5%, Lordship. In the other case, it has been shown as 9%. Lordship. I have to say this much, Lordship.
And Sabita Devi also interest. Sabita Devi, on what ground you are submitting? Sabita Devi judgment?
Interest part.
Interest.
No, one part is Rekha Bhai is on the pension part is not deducted.
No, that I have noted down. Only last two judgments.
Yes, interest part, Lordship. Sabita Devi is on interest where Honorable Supreme Court has taken 9% interest, Lordship.
9%.
9%.
Yes, class.
Lordship, this family pension, income of advocate, interest, okay, that I find that interest should be given in all cases. It is given from the, but the fact that the family pension was working as MLA, was an advocate, there is no document, Lordship. If I am an advocate, what this exhibited, Lordship, 5 exhibits are there. Exhibit 1 is the accident information report. Exhibit 2 is the FIR. Exhibit 3 is charge sheet. Exhibit 4 is Caesar list, and Exhibit 5 is PM report, PMR. There is no document that he was ex-MLA, he was an advocate. There is nothing. It cannot be presumed by the court, Lordship.
Documents will be required.
Lordship, that
Let madam, please.
so without that, the court has given 5,000, Lordship, in 2008, Lordship. I have checked the income, no minimum income or very skilled worker. Lordship, that also comes to in 2009, Lordship, highly skilled will be.
So we have a new judgment now from the Supreme Court.
That the wages is to be, when income is not proved, that's why I'm submitting.
Has to submit on the wages of
Wages.
skilled or unskilled worker.
Yes, that is what I'm submitting, Lordship. In 2009, this case was of 2008, Lordship. 2009, the wages for unskilled worker, it was 85 rupees per day. Semi-skilled, 80.
But advocate will be skilled, highly skilled.
So I'm coming to that, Lordship. I'm coming to highly skilled. Semi-skilled was 88 rupees per day. Skilled was 108 rupees per day. And highly skilled, here we come to, because they did not prove, 132 rupees per day. Lordship, that comes to 3,000, I've calculated, 3,960. Court has given 5,000 rupees. And I have a judgment from, I'm going to submit, Lordship, this judgment, Rani versus National Insurance, in which the Honorable Apex Court held that when income is not proved, in fact, in this case, what happened, Lordship, the tribunal had taken income of 3,000. High Court, what it did, because it was believing on a driving license, increased it to 10,000 per month income. Apex court said that is not correct because High Court didn't, without any, a person might have some driving license, but how is it that he was working? He was employed. So the Supreme Court said that maximum that can be notional income can be taken is 5,000. But now recent judgment has come, Lordship, that as insurance and also the court will be relying
That
on
new judgment.
yes, recent 3 days.
3 days back. Means.
I have it, Lordship, but I do not have the copy. That the insurance company. That's why I'm submitting, Lordship, this thing.
Justice Arvind Kumar, Justice Sandeep Mehta, I think.
Yes. I can give that judgment, Lordship. I can give that judgment because recently.
Judgment.
Yes. Because, Lordship, so when they did not prove that he was a MLA, no document, Lordship. If I'm an advocate, at least I have an ID that I am an advocate. How can the court presume, Lordship, that he was MLA or advocate or whatever? So court has very rightly given the compensation calculated.
MLA, maybe court can presume, but advocate, I don't know.
If court can presume, Lordship, court can presume income, Lordship. That is what the court did. Whereas it should have been in 2009, the accident was in 8. It will be even less. But 2009 also we take, that comes to 3,000 something. The calculation I am 3,960 it comes to. Court has given 5,000. Court has calculated as, so there is nothing wrong in that, Lordship. And Lordship, the amount given for as per Rajesh versus Rajbir, 1 lakh rupees to for loss of consortium, and as per decision 25,000 is funeral expense. As per Rajbir, that is page 32 of memo of appeal and internal page 9 of the judgment, Lordship. Lordship, what they are submitting is love and affection. It is for the love and affection was for the children. Here only the wife has filed the case, Lordship. There is no question of consortium, she is getting 1 lakh. But if we go by pronicity, that is 5 judge, Lordship, it will be 70,000. 40,000 only. And in total, Lordship, 70,000 and 10% increase in every 3 years. So as on today, it will be 84,700. That is already court has given more. About the interest part, I concede, Lordship, that yes, interest in all cases are given from the date of accident.
Yes.
But Lordship, if the insurance company has already paid.
So these 2 judgments are not required then? Interest she has
I'm just have to reply to one point.
No,
In our pleading, in our
she has considered that at the rate of 9%?
No, Lordship. No, not 9%. It should be at the bank rate, Lordship. Now bank rate, Lordship, 6 point some percent, Lordship. That also I can check. 6.3 something percent. 3 or 5.
I reply.
Question could be said.
6 point how much?
I'll just check, Lordship. Uh, 6.60 Axis Bank, Bandhan Bank, different banks have different, Lordship. But 6 point some interest.
Make it 7.
7. Okay, Lordship. For sir.
Lordship, I'm not saying.
But the thing is, Lordship.
I have given 2 judgments. One is 9%, one is 7.5%. Lordship could say. So for madam's claim is that.
No, I'll submit one thing, Lordship, on the interest part, Lordship. Already, if the insurance company has paid and they have received by say, no, sir.
50,000 we have.
No,
So for my instruction, I have no idea about the rest part. 50,000 has been given as a no fault liability, and that we have received. We have mentioned in the appeal memo.
4,05,000.
I have no idea. I have no.
Whatever, Lordship, if the insurance
remaining amount on interest on the
interest will be on the remaining amount only.
That's what we
because already.
No dispute on that.
But there is no remaining amount, Lordship. Because already the court has given 5,000 calculated.
I am coming on that.
And the consortium part is also more.
I am coming on that.
If anything, Lordship, I'll add.
Question of proof will come when they deny the facts. It is in our claim petition, we are advocate, they have never denied. It is in the evidence. Wife has examined herself as PW1, clearly mentioned in para 9. That I beg to state that age of my deceased husband 62 years at the time of said accident, and he was an advocate practicing in the court of Abhayapuri and Bongaigaon, in addition to being an ex-MLA. and the president of the All Assam Coach Rajvanshi Sandilani, and was a political leader and social worker of repute of the state of Assam. Not a single question, even not a suggestion of denial was put forward. Same fact was supported by the PW2. Para 7, I beg to state that age of my deceased relative 62 years. At the time of said accident, he was an advocate by practicing in the courts of Abhayapuri and Bongaigaon. I beg to state that Ponimedi became an MLA from Abhayapuri North and also contested the Dhubri parliamentary constituency. I beg to say that late Ponimedi became the president of All Assam Coach Rajvanshi Sandilani for several times, and until his death, he was the president of All Assam Coach Rajvanshi. Never has been not a single question, even never suggested. So question of proof, comparing an advocate with the skilled labor or labor, it will be an insult. That should not be. Income, whatever lordships may take, but cannot be treated as 5,000 only. He is a long-standing practice, a social leader, and having mass attractions in this locality. So he has a very solid practice in his job. So he cannot be treated with the labor or the minimum wages part also. No challenge, not a single, neither in WS
If I
or-
may just interrupt, advocates are actually daily wage earners. We are in the apex court also, it is submitted that we are daily wage earners.
I dispute that part also. But rest, I let.
Daily wage earners to some extent, we don't know. To what
Yes,
extent, we
maybe
don't know.
it might come to crores, but then we are daily wage earners.
Okay.
Not refuting lordship, in our written statement, we have refuted that, sir. Who has said it is to be proved.
Denied.
Denied, it is to be proved. To reflect to us.
We have given evidence. Proof means we have given evidence, and not a single question has been that no, he was not an advocate, he was not an XMLA, not a social recruit. Not a single. Lordship will go through the records.
Lordship, when they do not prove,
very brief.
what is the question?
Lordship, very brief. If Lordship asks me, I can read it out.
Lordship, when it is, they have to prove the claimant, it is not based. Lordship, the case is not dependent on what the defendant is doing or the opposite party is doing. Claimant has to stand on his own standing. They have to show, what is the difficulty in showing a ID that he was the MLA or he was the advocate? They did not. Just by making statements, Lordship, why should we ask a question which will put us in jeopardy? When it is not proved, we do not. Lordship, cross-examination is a very skilled thing. We should not ask question which is again prove and put us in. We did not prove. We did not ask that question, Lordship.
In fact, I am an advocate. I have to adduce evidence. I have adduced evidence. What is their cross? May I permit it, Lordship? Deceased Ponimedi was my husband. My husband died due to accident while my husband was going to Guwahati, then near Changsari. At the time of accident, I was at my home. I have claimed rupees 25 lakhs. It is not a fact that I am not entitled to get 25 lakhs towards compensation of that. This is much is only the cross. Not a single even suggestion that you are not the MLA, it is not your income, nothing. So on that count, Lordship will decide the matter.
I'll submit this Rani judgment about the income, Lordship, 5,000 income. Relevant paragraph, Lordship, here will be paragraph 13, 14 and 15, Lordship.
Relating to what?
Relating to income of 5,000. I'm supporting the judgment of the tribunal, Lordship.
Okay. So I'll have to ponder over it now. Would have put a specific point. There's only one question now. So let me see.
Yes, Lordship.
If you have an authority, any on that point, and you can help me
No,
out.
no. I'm not going to burden any more lordship.
No, these are, it's okay, but
Only so
there
far,
is a point to ponder, but.
so far group is concerned, lordship. Advocate, we have claimed, they have not denied that much.
So Rani judgment is helpful in that lordship. In that case, what happened? The High Court had even looked into the driving license and suppose even if now they say ki he was but they did not prove it. The Apex Court held that no, based on that only it cannot be. It has to be proved. That is what is the judgment.
But it has remained unrebutted that he is an advocate.
The question is not of lordship. If we ask a question, what will it? It is not a fact. It will come as it is not a fact. Why should we put our foot on that lordship?
Yes, yes.
We should not
You'll
ask.
be on the back foot. there.
Yes, we will be on the back foot.
I
Why
understand
should
your
we ask?
point.
Yes, that is the law of evidence.
They have to
lordship.
challenge.
That is the law of
Unless
evidence.
challenge, evidence has to be treated as proved. That is the law, lordship. Unless challenge, if no question, no challenge, evidence has to be treated as proved. If we put an I card, then again they will get, have you bring the issuer, issuing authority, all, again that will come. Lordship,
Okay. Third learned counsel, Mr. S.K. Poddar, appellant, and learned counsel, Ms. Adi Chaudhary,
Mojumdar.
Mardi Mojumdar, Poddar, respondent. Reserved for judgment and evidence.
And you're obliged to.
deeply obliged.
Pending item 7 for orders.
Lordship, application number 2773 and 2777. Copy I have served to the office.
For respondent number 4, I think they have not served any copy, Lordship, for the substitution application. There is a performer respondent number 4, Oil India Limited.
Oil India
They have not
Limited.
served any copy.
No, I'll take my copy. There is nothing left. There is nothing left. I can submit without copy also. I have filed the application for substitution in respect of appellant number 2. She was defendant appellant. Within 90 days, we could not file. Thereafter, we filed second application, substitution, setting aside abatement. That is another 60 days. That is covered under section 121 of Limitation Act. These two applications may be kindly be disposed of, so that the third application, limitation application, comes thereafter.
My lord, there is a application that is pending.
That will come later on because lordship.
No,
why
that
did
is relevant because the person who
becomes
filed that
problem for-
application
he doesn't
is
understand that it
dead.
is a problem.
Is dead. No, my lord, they have not served today. They have served this copy after the last date also. They have not served copy today. They have to ask again to court. And now there is a IA 4082 of 2024. Now that was pending and the deponent has died now. So that they have to inform the court what they are going to do about that.
Lordship,
That is closed now. That will be closed before.
I'm sorry to say that our 4048 is still pending. Why? Because at the time of filing the application, appellant number 2 was very much survived. Therefore, during his time, it was filed. Subsequently expired. Therefore, it becomes necessary for me to substitute names of legal heirs of appellant number 2.
That may be closed and
That cannot be closed. That cannot
their
be closed.
children.
Because these people will step into the shoes of the appellant number 2.
No, those children may be allowed to file a fresh case.
It becomes difficult when he doesn't understand the law, simple law. At the time of filing the application, limitation application, she was very much survived. Therefore, the application stands. Thereafter, when the matter came up, he died, she died. Therefore, I have filed a second application, that is your substitution application as well as setting aside abatement application. That is within time. So let both the application be allowed. Thereafter, let the limitation become. Let him argue on that point thereafter. Not at this time, not at this stage.
Within the period of limitation, so we will allow this to apply.
Yes, my lord, will allow this to addition. But the children, the substituted people may be given fresh liberty to file everything fresh, my lord. Instead of substituting the whole thing, which is already pending for a long time. That doesn't make sense now.
Fresh what?
Because the
No,
pending
because
case.
it cannot be. In that case, I'll be again hindered with that limitation petition. Because that was filed within time. That was filed within limitation when the person
That is
was
also subject to
surviving.
the other parties also.
Let us come, let us-
Instead of going so backwards, let us dispose of this.
Yes.
First and foremost, which is within the limitation which I can dispose.
Yes,
I'll
Lord,
dispose it
that
of.
is the point. That is the law.
We'll come to first which one, 2773? Or 2777?
Lordship. Substitution, setting aside abatement.
Learned Counsel, Mr. B.K. Bhagwati
Lordship.
is present for the applicant. Premi Damta,
Premi Damta.
Srimati Premi Damta and Sri Eliazar Bhingra, who has filed his application. Who have huh?
No, this application has not been, application has been filed Premi Damta or the Elgar Bengra. Elgar Bengra.
Okay. Eliazar Bhingra.
Yes, Lordship.
Premi Damta, who has who has filed this application under Order 22 Rule 3 read with Section 151 of the CPC, praying for substitution of legal heirs of appellant number 2 who passed away on 3/2/2025. Learned Counsel, Mr. Learned Government Advocate.
Yes, K.K. Bhattacharya.
Mr.
K.K. Bhattacharya.
K.K. Bhattacharya is present for respondent number 2, 3 and 4.
I'm for the respondent number 4.
2, 3.
I'm for the one.
For respondents 2 and 3.
Learned Counsel, Mr.
W. Rahman on behalf of Mr. A. Sharma.
W. Rahman is on behalf of Mr. A. Sharma is present for respondent number
4.
4 and Learned Counsel, Mr.
Muhammad A. Rahman on behalf of A.W. Aman.
A. Rahman is A. Rahman
A. Rahman on
is
behalf of
present
A.W. Aman.
on behalf of Learned Counsel, Mr. A. W. Aman for respondent number
1.
1. For respondent number 1. Full stop. This application is filed within the period of limitation and therefore no objection has been raised by the respondents to opposite parties. Respondent not opposite party লিখিবা যত respondent লিখছিলা তার opposite party লিখি দিবা respondent to কাটি দিবা. Therefore application is allowed the legal heirs of appellant number 2, namely how many? Etu heri page number 7. Etu hol page number 7 IA 2773 2025 page number 7. Etu likhi diba 2A, 2B, 2C, 2D allowed to be are to be substituted in place of respondent number 2 or appellant number 2 and amended full stop and amended cost title to be submitted full stop. Etu IA number 2777 AK likhi diba Learned Counsel same counsel. This application is filed under Order 22 Rule 9 read with Section 151 of the CPC, filed by the applicant praying for setting aside the abatement in substituting the names of the legal heirs of representative of deceased appellant number 2, Premi Damta. So Premi Damta has passed.
Lordship.
As the application has been filed within the period of limitation, no objection has been raised. Thereby, the abatement is hereby set aside.
Thereafter, let the matter come up for 4082 IA.
It will be disposable, no?
These two applications.
4082 will list it then.
Thereafter, if they have any objection, let them come up with objections.
Okay. IA 4082 to Likidiva list this matter on Puja vacation, after Puja vacation. 16 October.
Lordship.
On 16 October.
Hello.
May I please your lordship, my lord, although the matter is listed for hearing today, my lord, in preference to the earlier order, my prayer before lordship to take up the IA, my lord.
IA.
Yes, take up the IA only today, my lord. Because my lord, already your lordship, since the matter is pending since long and the petitioner has also, my lord, My lord, in this case, I would like to point out before your lordship, although my lord, while considering the prayer of the petitioner in this, here my lord, petitioner is convicted under section 20C2 of the my lord, 20B2C of the NDPS Act, my lord. Conviction is for 10 years, my lord. Here, my lord, before, although in this case, at the time of consideration of the IA, it is not required for your lordship to meticulous consideration of the evidences on record. Although, my lord, lot of time the matter earlier listed before lordship, he has also objected many a time. So I would just like to point out, my lord, two of the vital witnesses regarding, my lord, recovery of the conscious possession of those contrabands from the present petitioner. My lord, I may be allowed to go through the records. Record to conduct.
Indeed, yeah, NCR.
And I would also, my lord, point out the grounds he has taken in the petition, my lord. There are 7 witnesses in this case, my lord, prosecution witnesses. Teaser witness is, my lord, from PW 225. PW2. Exactly, he is one of the Caesar witness. I know the informant, so and so. The incident took place about 5-6 months back at the turning of Gulabganj. While I was boarding the passenger in a bus, I am not pointing out the facts because earlier your lordship has already heard the matter. And passenger in a bus, I heard a huge sound. Then I saw 2 Centro cars got collided with the police vehicle. I saw ganja in 2 Centro vehicles in the dashboard and headlight. People who gathered in that area also shouted ganja. Then police took my signature in a piece of paper as witness. Police told me that I made a witness for the recovery of the said ganja. This is the witness, my lord, evidence of PW2. Then PW3 is not vital because PW3 stated that I do not know the contents of the Caesar list. So I'm not reading PW3, my lord. PW4. About 7 months back, the incident took place. I heard a huge sound because of hitting of a police vehicle by another vehicle. I could see some bottles fell down from the vehicle after hitting the police vehicle, although he has mentioned that some bottles fell. Thereafter, with the help of crane, police towed those police stations. Thereafter, with the help of some mechanic, police opened that vehicle which hit the police vehicle, and in my presence, this is vital, police recovered suspected contrabands, and then I put
This is witness number?
Witness number 4, PW4. In my presence, police recovered suspected contrabands, and then I put my signature in the Caesar list. That is PW4. PW5. The incident took place in the month of January of 2023 at National Highway so-and-so. I saw 2 persons traveling in a Centro car hit the police vehicle. When they were asked to stop their car, I also saw some packets fell down from the said car after hitting the police vehicle. So here he has not mentioned about those contrabands were ganja, but he saw some packets fell down from the, because at that point of time Nakasaking was going on. Two central vehicles, my lord, initially, my lord, one central vehicle collided with the tanker, police vehicle. Thereafter, my lord, second central, which was also coming from that way, my lord, collided with the second vehicle. Thereafter, my lord, during that accident, some packets, my lord, fell down from the one of the vehicle. Then when police searched, those, my lord, huge quantity of contrabands were, my lord, recovered, not at the place of the Nakasaking, because those contrabands were sealed below. At that point of time, the place was entirely dark. Thereafter, my lord, in presence of the witnesses, police has taken both the vehicles in the police station, and in presence of independent witnesses, my lord, by calling two mechanics, my lord. Thereafter, police, my lord, charged the entire vehicle. Thereafter, seized all those, my lord, contrabands. So, my lord, here it is not required that, my lord, among all the
PW5 is also seizure witness.
yes, my lord. Although, my lord, some seizure witness number 3 here said police has, I do not know the content of the seizure witness, but PW4, my lord, he specifically stated that police recovered suspected contrabands in his presence. So, my lord, one of the seizure witness is sufficient itself. If one of the seizure witness, my lord, specifically mentioned that police recovered those contrabands in my presence, my lord, that itself is sufficient. And, my lord, regarding not only he, but other witnesses also, my lord, corroborate his statements by stating that my lord, at that point of time, the gathering people saw that some packets of ganja, my lord, falling out from those vehicles after that incident, my lord. So this is, my lord, regarding recovery part and statement of the PWs, my lord, those seizure witnesses. And regarding, my lord, compliance of section, my lord, 42 or 43, my lord, as per his argument, but because here my lord, your lordship, I would like to point out now page 33 of the judgment of the trial court. It is the discussion regarding 42 and 43 of the NDPS Act, because those contrabands were recovered, my lord, in a public place. Those are that, my lord, chance recovery at the time of Nakasaking was going on. So at that point of time, police recovered those contrabands. This is not in a, my lord, from any close place, from not any house or building. For that, my lord, as per my lord, provision section 42, my lord, any prior intimation, my lord, is required to be conveyed. Here, my lord, section 43.
Page 33, paragraph?
Page 33, your lordship may kindly paragraph, first paragraph, my lord, 1, 2, 3, 4, 5, 6, 7th line, from the 7th line. No? The expression transit in section 43 of the NDPS Act is applicable to the expression conveyance used in section 42 of the NDPS Act as well, which is evident from the provisions of section 49 of the NDPS Act, which authorizes an empowered officer.
Paragraph number?
Page 33, my lord, from 7th line, my lord, 7th line, 1, 2, 3, first paragraph, my lord. I am just pointing out only relevant portion, my lord.
Page 32.
Your lordship may kindly come to page 32, 32, serial number 29, from 29, I recall.
Page 32, serial number 20.
29 from. A
Page-
bare perusal of section 42.
Page 32 to 9. No, he don't know. Judgment.
From judgment.
Judgment of the page 20, 32. Page number would have. Judgment of it was page 28, 29.
Serial number 29.
No, it was.
Page 32.
In the appeal memo or in the eyes?
In the appeal memo.
Appeal memo something. Page 33. Page 33, no?
32, my lord.
32. All right. I'll come back after 5 minutes.
Yes.
It'll differ different from the.
Okay. Your Lordship, I would
Yes.
like to directly, Your Lordship may kind to serial number 32, my lord, without pointing out.
Mm.
I will do it. Regarding section 43 and 42, my lord. Hypothetically, in the present case, my lord, even if it is taken that provisions of section 42 is to apply,
Yes.
still it is a case where information has been duly conveyed to the superior officer. As there is no prior secret information of the illegal trafficking of suspected contrabands, there is possibly no occasion for PW1 to reduce the incident in writing and inform to his superior authority. However, PW1, my lord informant, has categorically stated that he informed the superior authority of her phone. Moreover, as per PW6, has informed the superintendent of police Dhuburi about the incident within 72 hours of the incident. Further, the authority letter dated 19/1/23 is practically not possible to receive by PW1 as the suspected contrabands were seized without any prior information in a nakaseki. So, my lord, here the regarding applicability of section 42 and 43 is very clear. Those contrabands were recovered in a public, my lord, public place at that point of time while nakaseki was going on. The son's recovery, although there is no requirement of complying of section 42 and 2, but here in this case, the categorical statement of PW1 that he, my lord, immediately, my lord, and PW6 also, that PW6 immediately within 74 hours intimated to the SP, and PW1 also categorically stated that he intimated to the superior authority, although this is not the requirement in the present case because those contrabands were recovered in a public place, son's recovery during nakaseki, my lord. And regarding, my lord, this is the point regarding 43. And regarding, my lord, recovery from the conscious possession, my lord. Now, from the seizure witnesses, it is very clear that from the conscious possession of the present petitioners, my lord, those seizure witnesses, your lordship, those are what are the matters on record. I am pointing out that, my lord, from the statement of the seizure witnesses. And regarding now, while the my lord conscious possession, those contrabands were found in possession of the present petitioners, my lord. Now, my lord, section 54 of the Act raises a presumption, and the now burden shifts on the accused to explain as to how he came into possession of the contraband. In the instant case, the initial burden is clearly discharged by the prosecution, and as it stands satisfied, the burden would shift to the accused to rebut the presumption. No doubt the standard of proof, your lordship, serial number 46 of the judgment, please quote.
Yes.
My lord, regarding 42 and 43, I clarified to your lordship, my lord. Now regarding, my lord, presumption, my lord. 46, my lord. Thus, section 54 of the Act raises a presumption and the burden shift on the accused to explain as to how he came into possession of the contraband. In the instant case, the initial burden is clearly discharged by the prosecution. And as it stands satisfied, the burden would shift to the accused to rebut the presumption. No doubt, the standard of proof required to prove the guilt of accused on the prosecution is beyond all reasonable doubt, and that it is preponderance on probability on the accused to rebut it. But in the present case, accused has failed to rebut the same when examined under section 313 CRPC. The accused took a plea of simple denial without any explanation. Accused did not adduce any evidence to buttress the stand that he is innocent. Accused did not even bother to take stand if the vehicle was private. So, my lord, regarding possession, it is also very clear. He failed to rebut the presumption by my lord preponderance of probability, my lord. It is not required for him to prove that beyond reasonable doubt. But preponderance of probability under section 313, there is no explanation. He has not adduced any evidence. Although, my lord, and one of the ground, my lord, what he has taken regarding that aspect, I would like to point out, my lord, he has taken in his appeal memo, my lord. And one of the ground he has taken, my lord. For that defense counsel was engaged by the owner of the vehicle. That is his ground, my lord. And ganja and fees also paid by the owner. That is ground number 13. As such, the owner of the vehicle managed the defense counsel not to submit the defense witness name before the court, not to disclose the actual fact of the case. Accordingly, the learned counsel advised the appellant not to ask defense witness when the appellant was examined under section 313 of CRPC. The learned counsel advised the appellant not to explain anything before the court if seeks a fast trial. Can these grounds can be considered, my lord? Because of, my lord, why he has not explained under section 313, why he has not adduced evidence. So, my lord, for consideration of the IA, although other points regarding other meticulous consideration of the other evidence is not at all required, my lord, all these 2 points regarding 42 and 43, those are vital. And regarding, my lord, conscious possession, I already pointed out to your lordship on the basis on the basis of these aspects, my prayer before lordship at this stage, my lord, his IA may not be considered, my lord.
Lordship, in my earlier submission, I have already said in this case.
That you have given for the appeal.
Yes, Lordship.
Yes.
Regarding this, I am telling something, Lordship. In this case, there was no any DW, Lordship. And trial was going on when he was in jail, Lordship. This is the fact that was saying 313. Actually, at that time, he was not in the in such a situation that he can defend properly, Lordship, because he was in jail. And regarding, Lordship, the individual witnesses, I already in my earlier submission already said there is big contradiction, Lordship. There is big contradiction, not only the individual witnesses, no any individual witnesses said that the police seized such amount of contraband from whose vehicle. There is no any clear statement from the individual witnesses that when the police exactly seized the contraband from whose vehicle, how much, it is not clear. And even the recovery boy, the driver of the recovery vehicle and the two operator also said that they do not know how much contraband police seized from the vehicle, and from which vehicle how much, it is not also clear, Lordship. And Lordship, regarding section 42 and 43, Lordship, I already submitted in my previous submission that police fails to fulfill the compliances under section 42, Lordship, because I am telling, and police also failed to fulfill the contraband compliances under section 42, 43 of our NDPS Act also. And there is big contradiction, Lordship, among the statement of PW1, that is informant, Lordship. And it is page number 6, Lordship. I am very sorry today that I have misplaced the copy actually. That's why the judgment is not along with me, Lordship, today. And PW6, that is IO also. IO is not clearly mentioned. His statement, there is big contradiction. And CW2, that is Sirostadar, Lordship. Sirostadar cannot say when the seized article took in his storeroom like this, Lordship. Lordship, regarding 42, Lordship, 42 clause 1, Lordship, Roman 1, Lordship, the seizure must be between sunrise and sunset, Lordship. It is said, Lordship. There is exceptional exception is there, Lordship, but it is said that the ground must be recorded in writing, Lordship. But the police did not write any sentence in the FIR or anywhere why he has seized the contraband at the midnight, Lordship, in the police station, Lordship. This is section 42 clause Roman 1, Lordship. Lordship, again 42 clause Roman 2, Lordship. Only the authorized police officer can seize and seizure the such offense, Lordship. But the police received the authorization letter next day, Lordship, which is not legal, Lordship. It is illegal, Lordship. It is clearly mentioned, Lordship. Kindly, I have left the one judgment, Lordship. Kindly, you can note, Lordship. State of Punjab versus.
Appeal. This is for the appeal. We are
Yes.
hearing on the bail petition and stay of.
No, Lordship, it is that I have explained 42 clause Roman 2. It is clearly mentioned in this judgment, Lordship. In such seizure is not legal, Lordship. That is state of Punjab versus Balbir Singh.
No. This is
No
for
need.
the appeal.
Okay, no. Lordship. And again, Lordship, 42 clause 2, Lordship, it says that.
No, please don't go to the appeal. We are not going into the intricacies of the judgment. He has already given why the 42 section is not applicable in this case. He has given the reasons. And then you have already argued in that appeal.
Lordship, he has explained 42 and 43,
Yes.
and I am going through that.
For 2 days, you have argued in the appeal. I have the argument recorded with me.
Yes, Lordship.
So again, we'll not repeat. I'll just pass the order today. I'll
Okay,
pass
Lordship,
the order
only
now.
2 minutes, Lordship, if you give me time.
No, but I have given you
Okay, Lordship.
2-3 days I have given you.
And another, Lordship, 43 is also important here, Lordship. 43, it says that, Lordship, the seizure must be in public place, Lordship. But what is the definition of public place? It is 42 in the NDPS Act explain, Lordship. Public place includes any public conveyance, hotel, shop, or other place intended for use by.
See. This is for the appeal. You are submitting on the appeal.
Okay.
We are considering only suspension of sentence and bail. And then you have given, you have placed your argument for 2 days. I have everything noted down with me.
All right, Lordship.
So I'll pass the order now. NDPS action like.
My last submission, Lordship, it is more about 3 years, Lordship. He is behind the work. Kindly consider the IN. I am waiting.
No, I'm rejecting it. Cannot consider the I.
Lordship, 43 and 42 was not compliance here.
It is relevant in the stay of sentence and bail. Maybe in the appeal it is relevant, but not in the stay of sentence.
But the Lordship, it is.
I'm taking up only the IA criminal 692. I'm rejecting it. I've already passed the order. I'm rejecting it. I'll only dictate it now. Heard learned counsel Mr. M. Rahman for the applicant. Who has filed his application under section 389 of the CRPC. With prayer for suspension of sentence. And with prayer for bail, whereby in connection with special case number 115/2024 whereby the learned special judge Dhuburi dated 26, white order dated 26/2/2024, convicted the appellant Mohidul Islam under section 22 within bracket B bracket close stroke within bracket Roman 2 bracket close within bracket C of the NDPS Act and sentence him to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 1 lakh with default stipulation. It is submitted that the appellant is behind bars for 3 years, which is almost half the sentence, half the minimum of the sentence under the aforementioned sections of law. Full stop. It is submitted that the appellant is highly aggrieved by the judgment and order dated 26/2/2024.
Lordship, I am not agreed, Lordship. I am not agreed.
Sorry?
I am not agree with the judgment, Lordship.
Okay, but it is written here, that's why I'm
Lordship.
dictating. Okay, to cut it here. Highly agreed to cut it here. It is submitted that the court did not hear any defense witness like the wife, the parents of the accused, the owner of the vehicle and the owner of the ganja. Full stop. Neither the investigation getting officer nor the trial court found out the actual fact of the case. Full stop. The appellant is a professional driver of a dumper and works under his master. The appellant is innocent as on the relevant day, two partners, namely Yusuf Dev Burman and Hormon Dev Burman of Tripura, called him as well as the other accused persons, called him as well as and the other accused persons, full stop. The appellant was requested by them to drive 2 vehicles purchased for a consideration of rupees 500 per vehicle, full stop.
$5,000.
For rupees 5,000 per vehicle. It is further contended that the police recorded the statements of the driver of the recovery van and 2 mechanical boys, but all of them stated that the cannabis was recovered from the vehicle bearing registration number AS23C-6256, but the appellant was the driver of the vehicle bearing registration number AS23C-4199. It is further submitted that the statements of the seizure witnesses clearly reveals that the seizure witnesses have not supported the prosecution case. The police took signatures of PW2 on a blank piece of paper. Full stop. PW2 also could not recall the number of the vehicle carrying the ganja. Full stop. his evidence clearly depicts that the seizure list was not read over to him, and he could not mention the amount of the contraband seized in connection with the case. So the other contradiction is that no pagination was evident in the Malkhana register. And the storage of the ganja in safe custody has been disputed. It is further submitted that there are contradictions evident in the evidence of PW1 vis-a-vis the evidence of PW6, the informant and the IO of this case. It is further contended the authorization letter was received on the following day, which is illegal. It is further submitted that there is every possibility that the appellant may be acquitted, and thereby the appellant is entitled to bail, and a sentence may be suspended. Per contra, the learned additional PP laid stress in his argument that the learned counsel for the applicant has laid stress on the violation of provisions of section 42 and 43 of the NDPS Act. Stop. 7 witnesses were examined in this case, and PW2 to PW5 are seizure witnesses. Stop. It is submitted that the evidence of seizure witnesses PW2, 3, 4, and 5 clearly reveals that they were present when 2 vehicles collided with each other at the time of Naga checking, and ganja packets were found in the central vehicle, no? In the central.
Yes, both the central vehicle.
In both the central vehicle, and one vehicle was being occupied by the applicant. The PW2 was the seizure witness who has not. Which was the seizure witness who has described everything?
Yes, seizure witness number 3 and 5, my lord.
It is stated that the seizure witnesses
No, sir, it is not clear in their cross examination, but
Police recover PW4, my lord. PW police in presence of PW4, those contrabands were specifically mentioned, my lord. Other witnesses, my lord.
that it is stated that the independent witnesses, i.e. the seizure witnesses,
Yes.
witnesses no, witness लिख दिया. PW2 has categorically stated that he could identify the accused person who stopped while he was boarding a passenger bus. He heard a huge thud, 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 and saw 2 central cars colliding with the police vehicle full stop. He also saw ganja inside the in the dashboard and the headlight of the Centro vehicles. And his signature was taken on a piece of paper. Full stop. I have considered the submissions at the bar and the evidence projected by the learned counsel for the applicant and the learned counsel and the learned additional PP. It will likhila nahi learned hard Mr. P both have learned additional PP being not likhi jano. At this juncture, it is not necessary to consider the intricacies and the merits of the case. Full stop. It is true that the appellant has been behind bars since the date of his arrest. That is since when?
Since my lord.
He was on bail? No, never on bail. Was he on bail ever?
No, no.
Since the day he was arrested in connection with this case?
January 2023.
I.e. since most highly so. (21/6/2023).
No, Lordship. January.
Order is 21/6.
Yes. Order, but he arrested on dated
19-1 FIR.
yes, 19-1 I think. 19-1 2000.
19-1
Oh, that is 19/1, no?
Yes.
Okay. 19/1/2023.
23, yes.
Yes, Lordship.
I have also scrutinized the reasons recorded by the learned trial court. Full stop. At this stage, while disposing of a petition for bail and for suspension of sentence, this court is hesitant to scrutinize the judgment and order to bring forth the merits of this case. However, this court is reluctant to grant bail and pass an order of suspension of the operation of the judgment and order impugned by the applicant. In view of the foregoing discussions, it is thereby in view of the foregoing discussions, the application under section 389 stands rejected at this stage. You can we'll list this for a hearing, appeal hearing.
Yes.
List this this application stands disposed of. Appeal to Likhita, both parties are represented. Partner nalage. This case is released from this case is released as a partnered matter. List this matter for hearing positively on. If it comes before me, I'll take it up.
Released, Lordship.
I'm releasing it. Or if you want to keep it before me, I'll keep it. But you see, you cannot keep on.
Partnered, it will be better, Lordship.
I'll keep it as partnered then. Partnered list, but it will come after puja vacation.
Yes, consider before puja. It will.
No, not
because
possible.
Interim is rejected.
No, not possible. Not possible before puja vacation. It will come up after puja vacation.
This is September.
14.
Release this matter on. Otherwise, I'll release it.
Yes. No need, Lordship.
I'll release it.
Yeah, no need.
I
No
won't
need to
release it.
release, Lordship.
Okay, I won't
Because,
release it. Then release this matter as partnered. See, if I release it, then some other court may take up before puja vacation.
Because Lordship,
I'll fix a date. Some other court may take up before puja vacation.
Hearing matter, your lordship, today your lordship has rejected, so after puja vacation would be convenient.
No, some other court will take up the hearing. If I
Okay,
release
only on next week one.
this matter, this
mean-
matter is released as a part heard matter. Full stop. Release this matter for hearing on data deduct before vacation. Second week what? Appeal to লিখিব, huh? 18 September. If this is comes up before this court, then I will also hear it. Argument দুটো পিন করে ফেললে ভালো হবে। একটু ডেটও লিখে দিও, হ্যাঁ। আজি কি আসলে?
Ending item 9.
Please, Your Lordship, my lord, this regular second appeal, my lord. The appellants were the defendants, 1 and 2 months before the learned trial court.
Appellants are the defendants.
Defendants 1 and 2 months. There are other defendants also. And the respondent number 1 was the plaintiff, my lord. Respondent number 1 herein was the plaintiff, my lord.
Plaintiff.
Plaintiff, my lord. And during pendency of this second appeal, he expired, and accordingly, respondent number 7 and 8 has been, my lord, substituted. 7 and 8 are the sisters of the original plaintiff.
7, 8 are sisters of
Original plaintiff, my lord.
original plaintiff.
So they are substituted, my lord, in this second appeal. Now, my lord, the suit was, my lord, number 37. For declaration of right title and interest, my lord. Page number 37 is the claim, and the prayer is, my lord,
Respondent number 7 and 8 are sisters of
the original
plaintiff.
plaintiff, my lord. who
Where,
are
no?
Substituted. yes.
Now they have passed away and
Substituted, yes, substituted, my lord. Now they are the main respondents. So in the plaint, my lord, the page number 43 is the prayer, my lord. Prayer in the suite was
page number 43.
43 is the prayer, my lord.
Prayer in the plaint.
Plaint, my lord, yes.
Okay.
My lord, decree for declaration of the plaintiff and respondent 7 is its right title and interest over land described in Schedule 1 below and stuck thereon. A decree declaring the defendant 1 to did not acquire any right title interest over the suit Schedule 2 premise by way of purchase registered sale deed described in Schedule 3 and decree for recovery of possession of Schedule 2. Schedule 3 is the sale deed, my purchase. Our 2 purchase deeds, the Schedule 3. So Schedule 2 is the suit land for which recovery was sought. And Schedule 2 premises by evicting the defendant number 1 and 2, his man, agent, servant. And D is the declaring the sale deeds described in the Schedule 3 below as illegal, void, inoperative, without consideration not binding upon the plaintiff and cancellation and delivered. So next, the temporary and permanent injunction against the defendant 1 to restraining them from making any transfer on respect of Schedule 3 premise. F, my lord, decree directing correction of land revenue record in respect of second RS Patta number 68 of Sunapur Moja, so and so. So, my lord, the cancellation of the our purchase deed is praised on the basis that our vendor had no title. This was the case of the plaintiff that since our vendor had no title, so our sale deed is void. Now the plaintiff, my lord, in the plain has, my lord, the property inherited by the plaintiff along with our vendor, my lord, is shown in the plaint, my lord, distributed in a plain. Page number, my lord, 39 by the plaintiff, my lord. So, my lord, page number 39, the distribution is shown that the predecessor of the vendor of the appellant, and the plaintiff, my lord, was one Nandolal Das, my lord, it is shown in paragraph number 3 of page number 39. That from Nandolal Das, they have, my lord, inherited, but there are 6 brothers, my lord, mentioned clearly in page number 39. 6 brothers from Roman 1 to 6 in page number, paragraph number 3, and 7 is their mother. So the distribution of the plaintiffs, their inherited property is that each of the brothers, my lord, inherited 1 kata 800 taka of land. And your lordship will find Roman 2 is one Sucharubala Das, daughter of Nityacharan Das.
Yes.
So Nityacharan was one of the co-patradar and one of the legal heirs of Nandolal Das, my lord. Now, my lord, your lordship, on this point, my lord, the substantial question of law was framed on 15/10/2015, my lord. This on the Sucharubala Das right on the property, my lord. 15/10/2015.
15/10/2015.
2015, man.
Yes.
Yes, my lord. Your lordship found that
5/10/2015.
yes, my lord.
Not 15/10. 5/10.
5/10 is 5/10. 5/10/2015. The 2 substantial questions of law, because the defendant's case is that this Nityacharan Das died unmarried, issueless, has no children. And the plaintiff's case is that Sucharubala Das is the legal heir of this Nityacharan Das, and accordingly she inherited some property, and that property is purchased by the plaintiff.
According to plaintiff or according to
According to
defendant?
plaintiff, this Sucharubala,
Nityacharan Das was unmarried.
and according to defendants, he was unmarried. According to plaintiff, Nityacharan was married and he has the legal heir Sucharubala Das, only Sucharubala Das. So on the basis of this, the substantial question of law number 1 is framed. Number 1, whether the plaintiff could derive right, title, and interest on the basis of Exhibit 2. Exhibit 2 was a sale deed, my lord, by which the plaintiff had purchased property from this Sucharubala Das. So Sucharubala Das sale deed is Exhibit 2. The sale deed executed by Sucharubala Das when the plaintiff had failed to establish that she was a daughter of Nityacharan Das. So it is the finding of the trial court that the plaintiff failed to establish that Sucharubala is the daughter of Nityacharan Das. It is the finding, my lord, of the trial court. And number 2, my lord,
So
Whether
this is not concurrent finding.
concurrent finding, my lord.
Concurrent finding.
The appellate court on other basis, it is upheld, my lord, not on this point.
Okay.
The trial court held that the plaintiff failed to establish that Sucharubala is the daughter of Nityasara. That is the finding of the trial court, my lord. So the first resolution of law, my lord, whether plaintiff could derive right title and interest on the basis of Exhibit 2 sale deed, by which he purchased from Sucharubala, Exhibit Sucharubala on the plaintiff, while the plaintiff failed to establish that Sucharubala is the daughter of Nityasara. So while he failed to establish the that she is a legal heir of Nityasaran, whether he could establish the right title of interest upon the said land. And number two, my lord, whether the learned lower appellate court was justified in decreeing the suit of the plaintiff on the basis of Exhibit 1 Jamabandi. Exhibit 1 Jamabandi, my lord, where the name of Sucharubala was found. But there was, in the name of the Sucharubala, the name of her father was not there. So the trial court held that it is not established that Nityacharan's daughter is Sucharubala. In the Jamabandi, her husband's name is there. So it is not established that she has inherited property from her father. So these two substantial questions of law, my lord. Number one is the whether the in the absence of establishing the relationship with her father, the plaintiff could derive right title interest over the said land.
Okay.
So this application of these two subdivision of law. So my lord, I again come to the page number 39, the case of the plaintiff, my lord. Page number 39, in the same paragraph, my lord, the plaintiff further case is that he purchased this share of from Sucharubala. Sucharubala got after the death of my lord, her daughter, her father, she got the father's share, 1 kata 8 lesa, and my lord, after the death of Ujjala Devi, the grandmother, my lord, died. Then the grandmother died, and the grandmother's share of 4 satak each of the sons inherited, and along with the sons, this Sucharubala also inherited. The case of the plaintiff is that. Along with other sons, this Sucharubala also inherited the share of from her mother 4 satak land. So the total land comes to each shareholder is 1 kata 12 satak. So these 6 brothers inherited total land 1 kata 12 satak. Then my lord, the case of the plaintiff is that thereafter, my lord, the another brother, page number 12, page number 14, next page, my lord. Another brother, Nogendra Das died, expired, my lord. It is shown, page number 40. And Nogendra Das share is inherited, my lord, by Dwarika Nath Das and Upendra Das. Upendra is the, my lord, father of the plaintiff. So Upendra is the father of the plaintiff. So Upendra's share comes to 2 kata 10 satak, and though Dwarikanath's share is not shown, it will also be 2 kata 10 satak. That is 1 kata 12 plus 14 satak. 14 satak, my lord, is the half of one share. 1 kata 12 sataks, half is 14 satak, my lord. So Dwarikanath is the
14 satak is?
My lord.
How many satak is 1 kata?
My lord, 16 satak.
16
1
satak
kata.
is 1 kata.
1 kata. So 1 kata 12 satak comes, my lord, 28 satak. 28 by 2 is 14 satak. So Nogendra's share, after death of Nogendra, he was also issueless, it is shown that Dwarika and Upendra inherited 1414. Dwarika is my lord, my vendor's father. Dwarika is my vendor's father, and Upendra is plaintiff's father. So it is shown that both
So
my
they are children of Nogendra.
yes, my lord, they are children of Nandolal. All 6 sons are Nandolal's sons. It is not disputed that Nandolal had 6 sons. It is not disputed.
Nogendra, Nandolal or Nogendra?
And Nogendra is the son of Nandolal.
Yes.
One of the
main, he's
yes,
the owner.
yes, my predecessor. And one son was Nogendra. Earlier, Nityacharan died and shown that Sucharu is his legal heir. Now Nogendra died, and it is admitted by both plaintiff and defendant that Nogendra had also no children, also died issueless. So it is shown that
Nogendra or Nitya Chandra?
Nityacharan, as per plaintiff, he has legal heir, but we disputed, defended. But Nogendra, both party admitted that he died issueless. Plaintiff admitted, defendant admitted. So Nogendra's share is, my lord, 2 kata, 14 sotak is inherited by Dwarika Nath and Upendra Chandra Nath. At that time, other brothers expired. So these 2 brothers, as per plaintiff, they inherited their share. So 2 kata 10 lesser. And then, my lord, the case of the plaintiff is that by exhibit 3, my lord, by exhibit 3 sale deed, my lord, the plaintiff purchased Nogendra's share. Exhibit 3, plaintiff purchased Nogendra's share.
It is sale deed.
Sale deed. Nogendra's share. Though it is shown that Nogendra inherited 2 kata 10 sotak, but in the sale deed, the land is 2 kata 12 sotak. In the sale deed, it is 12 kata 2 sotak. The plaintiff's purchase deed. Though in the plaint it is shown 2 kata 10 sotak is the share of money. So the claim of the plaintiff is that, my lord. Then, my lord, sorry, my lord, not Nogendra, it is Dwarika. Dwarika inherited 2 kata 10 sotak. Dwarika is my vendor's father. So the claim of the plaintiff is that Dwarika exhausted his title. Dwarika exhausted his title after sale by exhibit 3. After sale by exhibit 3 to the plaintiff, Dwarika exhausted his title. So the legal heir of Dwarika has no title to execute the exhibit 4 and 5. Exhibit 4 and 5 are the sale deeds of the defendants. So the case of the plaintiff is that the legal heir of Dwarika has no title to execute exhibit 4 and 5 in favor of the defendants. Defendant number 1 and 2.
So that is legal heir of Dwarika is the
Is that
plaintiff and defendant number 17?
No, not, my lord. Defendant number 3 to 6.
Or
3 to
legal
6
legal
of Dwarika. Legal heir of Dwarika is defendant 3 to 6. 3 to 6 executed the exhibit 4 and 5. So my lord, exhibit 4, the area of the land is, my lord, 3 sotak 1/4 gonda, my lord, and exhibit 5, 3 sotak 1/4 gonda. That is total 7 sotak 8 gonda.
Land of whose land?
My lord, we have purchased from the legal heir of Dwarika Das. Now that is the issue, my lord, whether the legal heirs of Dwarika inherited this area of land, total 7 sotak 8 gonda. 7 sotak 8 gonda.
So you have purchased 7 satak, 8
7
kathas of
sotak
land.
8 gonda by 2 deeds.
Defendant
1 and 2. Defendant number 1 and 2 purchased total 7 sotak 8 gonda from the legal heirs of Dwarika Das.
7 katha, 1 satak.
My lord, 8 gonda. 7 sotak 8 gonda. 8
7 satak, 8 gonda.
G. 8 G. 20 gonda equals to 1 satak.
By 2 sale deeds.
By 2 sale deeds. Equal area of land.
From Dwarika.
From the legal heirs of Dwarika.
You have purchased.
Legal heirs. That is defendant number 3 to 6. Now, my lord, the case of the defendants, my lord, written statement our 46, page number 46 to 51.
You have submitted a counterclaim.
No. 46 to 51 is our, my lord, WS.
Yes.
So our case is, my lord, that we have no dispute regarding the predecessor of the plaintiff and the father of our vendors, my lord, and that Nandolal Das, my lord, inherited Nandolal Das inherited, my lord, 5 kata 2 sotak 10 gonda. Our case is that, my lord, Nandolal Das inherited 5 kata 2 sotak 10 gonda of land. From his predecessor, my lord. And my lord, this 5 kata 2 sotak 10 gonda of land, my lord, distributed after his death to his legal heirs, which comes to 13 sotak 16 gonda. In our written statement, we have 13 C and
It will
6.
be at page
Yes, in our page 49, my lord.
49, paragraph C,
Yes,
19C.
Yes, madam. Paragraph C, we have mentioned that, my lord. Each of the son of Nandolal inherited 13 sotak 16 gonda of land.
Minu Zabo Pai. Yes.
Yes, my lord. And our further case was that, my lord, the wife of Nandolal, that is, my lord, Ujjola Devi. Ujjola Devi had, my lord, her own share of land of, my lord, 5 kata 7 sotak on the suit dag number. And 5 kata 7 sotak, after her death, it comes to 14 sotak 10 gonda to each of her son. So 13 sotak 16 gonda plus 14 sotak 10 gonda comes to 1 kata 12 sotak 12 gonda. In our written statement mentioned, my lord. So each of the legal heirs.
You just give me one calculation.
Offline, I will supply.
20 gonda is 1 chatak.
Yes, madam.
Earlier, I used to know this calculation, but I forgot.
Yes.
When I was in Karimganj, I used to know this
Very
calculation,
hard
but I
to
forgot.
remember, my lord.
20 gonda 1 chatak,
Yes, ma'am.
then
Then
16 katak,
16
1
katak,
katha.
1 katha. 16
16
katak,
chatak, 1 katha. And
20 katha.
20 katha, 1 bigha.
1 bigha.
Okay.
So, my lord, as per the defendant's, my lord, calculation, each share of the 6 brothers inherited from the father and mother comes to 1 kata, 12 sota, 5 gonda. It is mentioned in our, my lord, paragraph C, my lord.
Yes, I have seen. Paragraph
Yes.
6, paragraph?
Paragraph C, my lord.
Paragraph C, yes.
19 C, my lord.
Paragraph 19 C,
19
yes.
C, my lord.
I marked it.
We have shown, my lord. Then, my lord, since the case of the defendants was dead, Nityacharan has no legal heirs. So after death of the Nityacharan, my lord, Nityacharan's share is distributed by 3 brothers, Nogendra, Dwarika, and Upendra. Nityacharan's share, 1 kata, 12 sota, 5 gonda.
One katha?
12 satak, 5 gonda.
Was distributed between the brothers.
3 brothers, Nogendra, Dwarika, and Upendra.
Was shared,
Shared
inherited by the brothers.
by the 3 living brothers, my lord. That is Nogendra, Dwarika, and Upendra. At that time, Nogendra was alive. Nogendra, Dwarika, and Upendra. And that is, my lord, reflected in the Exhibit 1 Jamabandi. It may be, my lord, recorded. Exhibit 1 Jamabandi, it is mentioned that these 3 brothers inherited the share of Nityacharan Das.
Okay.
Exhibit 1. So may I continue?
Oh, yes. We will continue after the break. I think this will take some time. RSA 2012, I think it will take some time.
My lord.
If anybody seeks adjournment, I can grant adjournment.
My lord,
Otherwise, it will be left
item
over.
15, my lord, both of us, my lord, it may come after applications.
Which one?
Item 15.
Item 15. Kabak mati diyasun?
Come after applications.
Well, the 14th October, your lordship. 14th October, your lord.
14th October. Item number 15.
15.
এইটো মই বুকখন ইয়াৰ ভিতৰতে ভৰাই দিছো নোটবুকখন য'ত লিখি আছো যে আৰ্গুমেন্টটো
Date এটা দি দিব হা with the request your
item number 15
yes with the request all
just a moment meaning matla ni I think this will continue for some time.
Well, I have a request for adjournment in item 15.
Item
14.
Yes. I will grant adjournment. Whoever wants adjournment, otherwise remaining part, I think will be left over. Item 15 to Likhas as agreed by both sides. Is this
29.
matter on when did you suggest the date? He goes the date to
14 October.
14 October. And item 14? Yes.
item number 29
20.
14 on item 14.
Yes, item 14, yes.
Item
You're
number
for-
29.
you're for
item number 29 supplement.
Item 14, 23rd October.
23rd October, item 14, 23rd October. Please this matter on 23rd October লিখিলে হৈ যাব।
Item number 29 supplementary.
ইমান order কেলে দিছে ইমান এদিনত ইমান হিয়াৰিং ল'ব পাৰে নেকি এটা কেছ ইমান দেৰি লাগে হা এটা কেছত ইমান দেৰি লাগে ইমান 29 টা হিয়াৰিং when do you want
Yeah, 29.
when do you want
After vacation.
4th November.
Matter as agreed by both sides list this matter okay
4th November.
on 4th November
No, Lordship, they are taking adjournment. I'm
Okay.
ready.
What is your name?
Prayer of appellant, Lordship.
BK Borua.
Learned Counsel, Mr. B.K. Borua has prayed for adjournment. List this matter on 14 November. 4th November.
Obliged. Okay, one order has been due to inadvertent clerical mistake. On 1 September, it was being passed order, but it should be the common tomorrow, my lord, for rectification.
Tomorrow, you want to mention now?
Yes, I want to.
Now they won't take. Registry won't take, huh? Tomorrow morning you'll have to, registry won't take. Because it's in the order, top of the list. In the cost list, top of the cost list, it's in the after, only till up to 10:30. Tomorrow, I think your junior, you can send your junior.
Lordship, item number 13, we want adjournment.
13.
One
Learned
fifth.
Counsel, Miss
S. Sharma.
S. Sharma has
behalf
prayed
of
for adjournment. List them on behalf of?
D. Chaudhary.
On behalf of D. Chaudhary has prayed for adjournment. List the matter on 6 November.
Lordship, I got the judgment, the minimum wage judgment.
Okay.
Lordship.
Sandeep Mehta and Arvind Kumar, no?
No, Lordship.
Sanjay Karol.
Karol, yes.
Oh, please. Belagata date of delay. If you conclude within 2 minutes, yes, on 19 September. This matter on 19 September.
So, Your Lordship, I have placed the case of the plaintiff and the defendant before the trial court. Now, may I go to the trial court judgment, Your Lordship? Trial court judgment, page number 19, it starts.
199.
19. So, in page number 20, Your Lordship, the trial court placed the case of both parties. Now, the issue number, page number 21, the main issues, Your Lordship. Issue number 5, framed by the trial court. Whether plaintiff and pro forma number 7 and 8 acquired right title and interest over the properties mentioned in the schedule. Schedule 1. 6. Whether the plaintiff is entitled to recover first possession by evicting defendant number 1 and 2 from the schedule 2 premise of the plaintiff, whether the sale deed.
Earlier this argument was heard, I think. Earlier this argument was heard.
Earlier, I have just placed the case of the both
Of RSA
plaintiff and
for
WS.
For substantial questions of law.
Substantial of law I have placed before your lordship. Now the finding of the.
So you are stressing on issue number 5.
Yes, your lordship. Issue number 5 is the I think the main issue regarding right title and interest of the plaintiff over the suit lesson. So issue number 5, your lordship, page number 21 is the pleading of the plaintiff, whatever I have placed, your lordship. And page number 22 is the defendant's case. I have already placed before your lordship the distribution of the properties. Your lordship, I think the defendant's WS last part, I think it is remained. The how he showed that the vendor of the defendants have the title over some portion of the land, your lordship. That part I think I could not complete. That part is there, your lordship. In the WS part, page number 46. So in page number 49, your lordship, page number 49, paragraph 19 of the last part of the WS. After showing the land of the parties, Your Lordship, the last part, page number 49. May I read the second paragraph, Your Lordship? Furthermore, on the death of the Nityasaran, his share devolved on Nagendra, Darika, and Upendra, the three surviving brother. And Darika got 9 sotak 8 gonda out of inheritance of 1/3 of 1 kata 12 sotak 5 gonda. Hence, Darika, Nagendra, and Upendra became owner of 2 kata 5 sotak 13 gonda of land each. Later, Nagendra died, leaving behind the Upendra and Dwarika. Hence, both the brothers became the owner of 1 kata 2 sotak 16 gonda of land on the death of Nagendra. So, Dwarika's total interest in the sweet patta is 1 kata 12 sotak 5 gonda plus 9 sotak 8 gonda is the share of Nityasaran plus 1 kata 2 sotak 16 gonda share of Nagendra. 1 kata 12 sotak 5 gonda from father and mother, my lord, and 9 sotak 8 gonda from Nityasaran's share, and 1 kata 2 sotak 16 gonda is from Nagendra's share. So the total share of Dwarika comes to 3 kata 8 sotak 9 gonda.
See, it's okay. They have shared and all, it's okay.
Yes, my lord.
Was there any partition that they have sold the land?
No, no.
Without partition, they have sold the land.
Yes, my lord. Both, my lord. Both share. The plaintiff also sold one person also purchased. So there is no partition. So after this, my lord, the next 4 lines may I read, my lord. Then if the sale of plaintiff is taken into consideration, although it is not admitted by the answering defendants, the extent of interest of Dwarika 3 kata 8 sotak 9 gonda, now deducting his alleged 2 kata 12 sotak, that is Dwarika sold to the plaintiff, exhibit 3 to the plaintiff, the remaining interest is 12 sotak 9 gonda. So, my lord, the defendant's case is that the vendor of the defendant inherited this 12 sotak 9 gonda of land, and out of this they sold this 7 sotak to the defendants, 7 sotak and 8 gonda land to the defendant. So this is the case of the defendant. Now, my lord, the trial court, will come, my lord, page number 19. Judgment of the trial court, my lord. So page number 19, the relevant portion is page number 22, my lord.
Page 22, yes.
22, second paragraph, my lord. After considering the distribution as given by both the sides.
Yes.
My lord, page number 22, second paragraph, my lord. After considering the distribution as given by both the sides, I find that the distribution is more and less the same. But the point of dispute is that plaintiff claimed that Nityasaran Das died, leaving behind him his only daughter, Susarubala Das, and the share of Susarubala has purchased by the plaintiff. On the other hand, the defendant's claim is that Nityasaran died issueless, and after his death, his share of land devolved upon his surviving brothers, Nagendra and Upendra. Now, let me examine as to whether Nityananda died issueless or has daughter Susarubala. Plaintiff in his plaint stated that Nityasaran died, leaving his only daughter Susarubala Das. But in land revenue record, in respect of sweet patta, in entry number 4, that is my exhibit 1, my lord. Nagendra, name of Nagendra, Dwarika and Upendra were recorded as legal heirs, and as such entry number 4 is illegal. It is the claim of the plaintiff, my lord. Therefore, it appears from the statement of the plaintiff that the name of Susarubala is not there in the land record. So it is admitted by the plaintiff that after the death of Nityasaran, his 3 brothers recorded as a legal heir, his property inherited by 3 brothers. Therefore, it appears from the statement of plaintiff that the name of Susarubala is not there in the land record. Plaintiff contended that the entry was illegal. In respect, I inspect the relevant entry number 4. It is written that as per order dated 25/3/60, it is important, my lord. 1960's correction is there. The record is corrected in the year 1960. The name serial number 789 written in place of serial number 5. Serial number 5 is the Nityasaran. And 789 is the Nogendra, Darika, and Upendra. On inheritance, the serial number 789 are Nogendra, Darika, and Upendra. There is no name appeared as Sucharubala Devi. The plaintiff gave explanation the entry is illegal. The word illegal connotes some sort of allegation of violation of law. As we know, the entry in the land record are made by LR staff as per order of the settlement officer. The entry was also made long back in the year 1960. The settlement officer has not been implicated as a party in the suit. As the plaintiff used the word illegal, so he ought to implicate him as a party. Plaintiff submitted the sale deed by which he purchased land from Susarubala. The sale deed is marked Exhibit 2. I have gone through the Exhibit 2. It appears that the vendor of the deed is one Susarubala, wife of Lal Mohan Das. During argument, learned counsel for the defendant submitted that the identity of Susarubala as the daughter of Nityasaran is not established, as her father's name is not written in the deed. During cross-examination, PW1 replied that he has no other document except Jamabandi, Exhibit 1, to show that Sucharu is the daughter of Nityasaran. Plaintiff has not adduced any independent witness to show that the Nityasaran has a daughter, namely Susarubala. Let now turn to the defendant side. The defendant 326 have not come to the witness box. 326 was my vendors. They, in support of his claim, DW1 is the defendant number 1 in this suit. The defendant number 1 to 4 jointly submitted written statement. Defendant number 5 and 6 filed joint written statement and stated that the answering defendants accept the written statement filed by the defendant number 1 to 4, and it may be read that the written statement of defendant 1 to 4 are the written statement of the defendant number 5 and 6. The allegation of plaintiffs against the defendant number 1 and 2 are not similar to the defendant number 3 to 6. In the examination in chief, DW1 deposed all the facts which has happened before his purchase, and those facts is not supposed to be his personal knowledge. The result of such deposition reflected in cross. In the cross, DW1 replied that he cannot say about the corresponding CS patta number of dag, and patta quantum of land. He also cannot say in whose name patta was issued. He cannot say the name of pattadar. He also replied that in his chief para 10, he has mentioned name of Rati Mohan, Purna Mohan, and Nandalal, and he cannot say their father's name. These are not relevant, my lord, these persons. He also forgotten the name of Darika, Nandalal, Rati Mohan, etc. in the patta. It appears that DW1, except his purchase, cannot say anything. In the written statement, the defendant has given a details of distribution of share, but during cross, he replied that he cannot say anything. Therefore, it is clear from the cross of DW1 that the abatement made by the defendant in their written statement has not been supported by oral evidence. The question regarding Sucharubala has got no supporting evidence from the defendant. The DW1 who cannot say the name of Pattadars, the share of Nandolal and others, DW1 who answered that he forgot how many sons and daughters Luson Das left behind, then how can he say Nityasaran Das has or has not any legal heir? It is the claim of defendant number 3 to 6 that their father got the share of Nityasaran Das, but they have not come forward to support the case. Fact, plaintiff could not prove, this is important, my lord, plaintiff could not prove beyond doubt that Sucharu is the daughter of Nityasaran, but at least oral as well as documentary evidence has been led by him. From the sale deed of Exhibit 2, it is not fully established that Sucharu is the daughter of Nityasaran, but there is in fact a registered deed whose vendor is Sucharubala, and the deed contains the land of suit patta and dag. In absence of any supporting evidence by the defendant number 3 to 6, I find that the preponderance of probabilities is in favor of the plaintiff. Plaintiff also exhibited the original sale deed by which he purchased the land from Sucharubala and Darika. So on the basis of sale deeds, my lord, the learned trial court held that Nityasaran is the daughter of Sucharubala. That cannot be, my lord. A registered deal, the Sucharubala may have purchased the land from any other person. It may not be the inherited land she inherited from her legal heirs, his father. There should be some documentary evidence. There is no documentary evidence, not any oral evidence. The plaintiff did not adduce any evidence, any independent witness that Sucharubala is the daughter of Nityasaran. So the learned trial court, on the basis of preponderance of evidence on the basis of a registered sale deed, held that Sucharubala inherited the land, held that Sucharubala is the daughter of Nityasaran. Though it is clearly mentioned in the judgment, finding is that the plaintiff failed to establish the relation, that Sucharubala is the daughter of Nityasaran. And these two documents not proved, my lord, as per law before the honorable court, my lord, trial court. These documents 2 and 3 not proved. The plaintiff proved our sale deeds, my lord. Our sale deed proved before the court, exhibit 4 and 5, by calling the witness from the sub-register office. The records from the sub-register office brought to the court, and as per law, our sale deeds proved by the plaintiff, and his deeds is not proved by, though he has just submitted the documents, but he has not proved by calling the records, my lord, or calling the officials, my lord, from the sub-register office. So, my lord, regarding my lord, I will later on go through some of the judgments, my lord, regarding the burden of proof, my lord. The plaintiff's burden to prove that he has the title, my lord, because this suit is for right title and interest. So, I will place some judgments, my lord, that it is the duty of the burden of the plaintiff, my lord, to prove his case. And the law is that, my lord, that the oral evidence of the defendant cannot be taken. The witness of the defendant cannot be taken to prove the case of the plaintiff, my lord. I will place the judgments, my lord. Though there is in the cross-examination of the defendants, my lord, he could not answer some of the questions, my lord, regarding the description of the land or the name of the persons. But my lord, this cannot improve the case of the plaintiff. Plaintiffs cannot take the advantage of the weakness of the defendant. I will place the judgments. So, my lord, in the light of the above discussion, I therefore held that distribution of land as laid down by the plaintiff is correct and acceptable, and as such, I opine that plaintiff has right title and interest. So, my lord, on the basis of two sale deeds, those are not proved as per law, the trial court held that the plaintiff has the right title and interest. That's my issue number 6 and 7, man. As these two issues, 6 and 7, regarding, my lord, the recovery of possession and, my lord, my cancellation of my sale deeds. As these two issues are interrelated, these two issues are taken together for discussion. The plaintiff in his plaint stated that on 6/11/2000, the defendant number 1 and 2, taking advantage of the absence of the plaintiff, forcibly took possession of Schedule 1 properties, and when the plaintiff raised protest, then the defendant submitted that he purchased the land from the defendant 3 to 6. Therefore, it is admitted fact that defendant number 1 and 2 are in possession of the land. It is also admitted that the defendant number 1 and 2 claimed to purchase the land by the registered sale deed from 3 to 6. It is already settled in the foregoing issue that defendant could not establish that their father, Darika Das, has title over the suit land, and as such, the defendant number 3 to 6 has not inherited the suit land, and the sale by them is void, being sale without any right title over the suit land. Therefore, I opine that the sale deed described in Schedule 3 of the plaint is void and inoperative. So, since my lord, my vendors did not come to the witness box, so the honorable court held that they failed to establish their title of their father. But it is not the case. It is the case of the plaintiff, my lord. Plaintiff's case, he has to prove that he has the right title interest over the said plot of land. So this is the finding, my lord, and the other issues are accordingly, my lord, decided. Now, my lord, may I come to the appellate court judgment, my lord, on page number 5 onwards. So, my lord, this honorable court framed the substantive question of law number 1, my lord, that in the absence of proof that Sucharubala is the daughter of the Nitya whether he could establish his right interest. So it is clearly, my lord, clear finding of the trial court that the plaintiff failed to establish the relationship, my lord. Page number, my lord, 12, page number 5 onwards, my lord. So issue number 5, my lord, page number 11. Page number 11, my lord, issue number 5 by the appellate court, decision of the appellate court, my lord.
Yes.
My lord, may I read, my lord?
Yes,
Issue number 5, plaintiff advanced his evidence as PW1. In his evidence, he stated that by exhibit 2, he purchased 1 kata 12 sotak of land from Sucharubala Das, and exhibit 3 purchased 2 kata 12 sotak of land from Dwarika Das, and both lands were appertaining to Dag number 230. After that purchase, PW1 had possession over 6 kata 8 sotak of land in Dag number 230, including share of 1 kata 12 sotak belong to pro defendant number 7 to 8. PW1 enjoyed the land belonged to his sister, pro defendant 7 to 8, as they had been living there in their respective husband's house. Schedule 1 is the land which was under possession of plaintiff, and defendant number 1 and 2 allegedly dispossessed the plaintiff from a portion of land which has been described in Schedule 2. PW1 proved the exhibit 4 and 5 are the two documents through which the defendant 1 and 2 alleged to have purchased the land in Schedule 2 from defendant number 3 to 6. PW1 further stated that the defendant number 3 to 6 are the heirs of Dwarikanath Das, but exhibit 2 Dwarika Das sold out his total land in Dag number 230 to him. My lord, this is to be noted, my lord. It is a perverse finding, my lord. This Dwarika Das sold out his total land, because in the sale deed exhibit 3, my lord, it is mentioned that in the boundary, my lord. May I go to the exhibit 3, my lord?
Yes, exhibit 3.
3 sale deed, my lord.
In the
LCR, my lord.
LCR like
Exhibit 3 to
LCR. গোটেইখিনি নহয় দেই, exhibits খিনি।
exhibit 3.
এই ফাইল C, D সেইখিনি একদম দৰকাৰ নাই। ফাইল A, B। এনে লিখা থাকে exhibits বুলি লিখা থাকে। Demonstrate. Mysterious case to the itu hindi upor bang itu nomor dia bisa itu apa ini? Jadi kita bisa RSN. Mistress जाने की ना सुस्पी अजीब नहीं है एकदम अलग है सीन जो है हम तो करना है प्राइवेट क्लास नहीं तो ये है ये तो लगा Issues, written statement, judgment, agreement. Deposition, cross, list, we can do it. Exhibit?
Exhibit 3, my lord.
Exhibit 2.
Second page, my lord.
Exhibit 3.
Exhibit 3, second page.
Exhibit 5, exhibit 2. Exhibit 3, second page.
Second
yes.
page, my lord.
Yes.
Learned appellate court held that Dwarikanath sold his total land, my lord, in the 230. But the second page, my lord, in the last part, my lord, it is mentioned, I read it is Bengali, my lord, version. It is the boundary, I will read the boundary, my lord. The Protham Khonder, in the second part, last portion, my lord, Protham Khonder, Rejoripa.
Exhibit 3 is only one page.
1, 2, 3 page here, my lord. I have the copy.
That is exhibit 4. Three pages exhibit
Maybe, my
4.
lord, there is some mistake in the numbering, my lord. It is a sale deed of 2873, my lord. 20873.
This is exhibit 1, 3.
Yes, my lord. Date 20873, my lord, in the first page. Registered on 20 August 73, my lord. Yes, my lord. The second page, my lord.
Yes, second page.
Second page.
This is exhibit, no, there is only one page here.
This is, my lord, of Dwarika's sale deed, my lord, Dwarika.
Uday Shankar Das.
Uday Shankar purchased from Dwarika Nath Das on 20 August 73.
Dwarikanath Das. Oh.
Dwarika Nath Das.
Yes.
So second page is there, madam. I think it is certified copy or something. I have.
Okay, yes. Please read.
Second page, last part, I read Pratham Khonder Ditya Rijoripa 68 nong pattar 230 Dage, your lordship got it.
A from D variation.
It is second page, this is the first page. ঠিক আছে 873 2873 yes, that was it. That's 230. Last part. 230.
You have taken a
Yes.
copy, I think.
Yes.
It's last paragraph, no? Schedule.
Serial, in the schedule it is mentioned 230 dag number, 230 in the schedule, in the below.
230 dag number.
230 দাগে my lord মোট 2 কাঠা 1200 টাক জমি my lord
2 কাঠা 1200
যাতে
জমি
yes my lord যাতে পূর্বে my lord পূর্বে 236 দাগের জমি পশ্চিমে 230 দাগের অবশিষ্ট জমি remaining part of that dag my lord.
Yes.
So, in the boundary, my lord, the remaining portion of the vendor is their land. It is mentioned, my lord. But how the appellate court held that he has exhausted his after this sale, my lord. It is mentioned in the boundary that he has some other land in the western part, my lord. And that western part is purchased by present,
I think appellate court did not look into this schedule, I think.
did not go, my lord.
Mm.
So this western part, my lord, the present schedule, the purchase by the defendants, my lord, is this western part.
30 দাগের অবশিষ্ট জমি।
অবশিষ্ট জমি, remaining part, my lord, of 230 dag. So, my lord, your lordship now go 4 and 5, my lord. 4 and 5.
I'll just mark here, okay?
Yes, my lord.
Exhibit 3.
Yes, exhibit 3, my lord. Schedule maybe, my lord. Mark, my lord. Yes, as per schedule, he has
Exhibit
some portion
3.
of land, my lord, to the western portion.
Exhibit 3 schedule shows schedule shows at the western side land pertaining
Of exhibit 3.
land of dag number
230, man. Dag number 230.
Okay. Yes.
And that is the 2-3 dag is the sweet land. Present sweet land is the 2-3 dag number. Dag number 230.
So according to you, trial court has wrongly held.
Yes, my lord. This
that
ending is wrong, my lord.
Dwarika
That he has exhausted his, my lord. Share, my
So
lord.
trial court wrongly held. What is his name?
My lord, date of the, my lord.
That exercised his rights?
My lord, date of the sale deed, my lord.
No, the name of the person?
Dwarika.
Dwarika, na?
In Dwarika, DWARI.
Dwarika.
Dwarika Nath Das.
Nath
Das. my lord.
Das. Exhausted his
His title.
his title.
His title.
Okay. All right.
And my lord, this my lord, deeds by which the plaintiff claimed, my lord, it is not proved as per law, my lord. It is not proved as per law. Now, my lord, PW2 is the, my lord, official of the sub-register office. PW2, my lord, I am reading, my lord, of the page 11. my lord.
Yes.
Page 11.
Yes.
PW2 proved the exhibit 4 and 5. Exhibit 4 and 5, our purchase deed, my lord. Are executed against the land in dag number 230. So we need not prove our sale deed. We have not proved, my lord. It is already proved by the plaintiff, my lord. Our sale deeds. So our sale deed is proved by the plaintiff, my lord, by calling the officials PW2. PW2 proved the exhibit 2 and 3. Though we have exhibited, my lord, as the exhibit go and go. Exhibit 2. Exhibit 4 and 5 are the exhibit go and go of the defendant, my lord. GA go and GH go. 4 and 5 are the go and go of the defendant's exhibits.
Okay.
Certified copy of the purchase deed. So PW2 proved 4 and 5 executed against the land of dag number 230. So 4 and 5 are of the same dag 230.
All right.
Now, my lord, the defendant number 1 in his evidence stated that the suit land falls in CS Patta 62. CS means, my lord, cadastral survey. Before the, my lord, the settlement, first settlement and resettlement, it was the dag number 62, Patta number 62, and dag number 266, 267, and dag number 266 resurveyed 189 of RS Patta number 169, and it was again resurveyed.
RS is what?
So, my lord, resettlement, my lord. Resettlement operation, my lord. So it is not disputed, my lord. The dag number, Patta number, not disputed by the plaintiff or the appellant. It is admitted by both parties that the final Patta is 68, my lord. Though it was earlier 62 and 69, final Patta is 68, and the final dag is 230 and 228. Two dag is there. So, my lord, DW1 further stated that Dwarika Nath's total interest 3 kata 8/9 gonda of land, which I have already, my lord, shown the distribution that Dwarika's interest is shown. DW1 also stated that he purchased land measuring 2 kata. It will be, my lord, 3/4 gonda. It is wrongly typed, my lord, from the heirs of Dwarika Nath Das.
Actually, 4 is also 8.
Yes,
Assume-
my lord.
assume-
Yes, my lord. That is
His English
that is
also is
normally
wrongly typed.
in typing, my lord. So it is 3/8 gonda. It will be 230 and second as pattern number 68, deed number 211/2000, and defendant number 2 also purchased 3/14 gonda. It is correctly written, my lord, here 3/14 gonda of land from the heirs of Dwarika Nath Das. I have gone through exhibit 1 Jamabandi very carefully. The note number 46 of and 8 made on 27/11/75 are found relevant. So, my lord, we will go to the
Jamabandi.
exhibit Jamabandi, my lord. Exhibit 46 to 46, it is a 46.
What is the Jamabandi exhibit?
Exhibit 1, my.
Exhibit 1.
Exhibit 1. They have exhibit 7. 1, and we have exhibited as exhibit
Exhibit 1, yes, I got it.
1.
Mm.
46.
Exhibit 1, note number?
Here it is mentioned, my lord,
46
note number
8.
46. I think it will be 4 and 8 or thing, because I have not found 46 in the exhibit 1, my lord. I think there may be some typing error. Error, because exhibit, my lord, in note 4, in the right column, my lord, 1, 2, 3, 4, note 4 is there in the right side column, my lord.
I've seen.
Yes, my lord. Here it is mentioned, my lord, that Chitar 25/3, Chitar 25/3/60 तारीखेर हुकुम मते उंग हुत्रे, उंग मतलब, my lord, उत्तराधिकारी हुत्रे 5 नং तले, 5 नং, my lord, नित्यशरण in the first column, my lord. Nityaswaran, my lord. Stole 228/230 dage Esmalite, my lord. It is Esmalite 789. 789 is Nogendra, Dwarika, and Upendra.
789.
789. And Dwarika is the, my lord,
789.
Nogendra, Dwarika, and
Yes,
Upendra.
I got it, yes. Nagendra, Dwarika, and Upendra.
So there is no Sucharubala.
No Sucharubala.
No Sucharubala. So if there was a legal heir of Nityaswaran, her name would be recorded here along with this. Next, my lord, 6, my lord, 5, 6, 26, 6, my lord, note 6. Jomir 26/6/71 हुकुम मते उत्तराधिकारी 7 stole. 7 means, my lord,
Yes.
this
The person who died.
This Nogendra, my lord. I have earlier, my lord, placed before your lordship that Nogendra died issueless, and after Nityacharan, Nogendra died. So his share is by these two living brothers, Dwarika and Upendra, inherited, my lord.
Putre 7.
My lord, 7
10.
died. 7 died, and 8 and 9 inherited.
Okay.
Now, my lord, the name of Sucharubala is there. 16, serial number 16. 16, my lord.
16, yes.
16, my lord. Here, my lord, her husband's name is there. Not the father's name is there.
Lal Mohan Das. 4 and 6, no?
4 and 6, my lord. So here, I think it is written 46, it may be 4 and 6, my lord.
Yes.
In the judgment, 4 and 6, I think it will
Exhibit
be,
1.
it will be 4 and 6, my lord. Though it is typed as 46.
Okay.
Yes, my lord. My lord, there is one note, though there, my lord, though it is not mentioned in the Jamabandi, my lord. 7, it is mentioned, my lord. Sucharu's name is there, though it is in place of Nogendra, my lord. 7. In place of Nogendra, after Nogendra, it is mentioned that she also inherited some portion of land. But it is not mentioned that she is the daughter of Nitya Saran. Now I read, my lord, the page number 11, last page, last paragraph. I have gone through the exhibit very carefully. The note 4 and 6 made on the on 27/11/75 are found relevant. The name of the plaintiffs mutated in the Jamabandi. The entries made in the Jamabandi is presumed to be correct until contrary proved as per 41(2) of the Assam Land Revenue Regulation. No rebuttable evidence has been advanced in this aspect. So this finding also, my lord, come in favor of the defendants, my lord. That as per section 41 of the Assam Land Revenue Act, if not challenged, my lord, it is to be correct. So the land of the Nitya Saran is inherited by his 3 brothers, so it is held to be correct. On the other hand, the Jamabandi exhibited by defendant number 1 as exhibit 4 relates to DAG number 69. Thus, the document produced by defendant number 1 failed to show that defendant number 1 and 2 accrued right over the Schedule 2 property by way of purchase from heirs of Darikanath. So this finding, my lord, though Darikanath's name is there, but this finding has no basis, my lord. This finding that they have no titles, my lord. There is nothing, my lord, supporting reason is there. Only held that they have no title. Therefore, the plaintiff succeeds to establish that the right title and interest over the properties mentioned in Schedule 1, the decision advanced in the trial court is found not to be contrary. So this is the finding, my lord, only on the basis of section 41 of the Assam Land and Regulation 1886. The appellate court finding only on this section 41. The 41, my lord, also comes in favor of the defendants, because 41's 1960 record, the learned trial court elaborately discussed that the 1960, my lord, when the this note was made by the settlement officer, it is not challenged, and the settlement officer is also not made a party in the suit also. Okay.
Okay.
So, my lord, the appellate court filing on the basis of this section 41 of the land records 41 2.
Regulation 41.
Yes, madam. Assam Land and Revenue Regulation 1886. Section 41 2.
Yes.
My lord, every entry in the record of rights made under this section shall, until contrary is proved, be presumed to be correct. So it is presumed to be correct that, my lord, this Sucharabala is not the legal heir of the Nitya Saran, my lord. So this comes in favor of the defendants, my lord.
All right.
So my trial court's finding is that there is a sale deed. So trial court held that Sucharubala is the, my lord, inherited the land, sale deed. And Lionel Appellate Court held that since the 41 is there, so it is not challenged. Now, my lord, I will place some judgments, my lord. It court. Court order. Court order. Well, I will read first, my lord, the 2017 5 GLT, my lord, on the death of Suleiman Ali. Suleiman Ali judgment, my lord.
Yes.
I will place regarding, my lord, few paragraph regarding the weakness of the defendant. The plaintiff cannot rely on the weakness of the defendant. 2017 86.
Yes.
My lord, page number.
Paragraph 22 to
Well,
25.
paragraph 25, my lord.
Paragraph 25.
25.
Yes, paragraph 25.
My lord, in Ramdas versus Selim Ahmed reported in Supra, the predecessor in interest of the respondent preferred a suit for declaration of title and injunction contending inter alia that the said predecessor interest Corimbox acquired title to the suit property by way of purchase from Sharifan, who acquired title in turn from so-and-so, a will. The appellant denied the title. The trial court dismissed the suit as the plaintiff failed to prove the title. The first appellate court upheld the finding. In the second appeal, High Court, placing reliance on the copy of the will, and as nobody objected to it, accordingly held that Sharifan got title to the property. Therefore, on challenge made, Honorable Apex Court held as follows. That was a concurrent, my lord, and the High Court, my lord,
Yes.
passed, my lord.
Went to Supreme Court.
Yes, Supreme Court held, my lord. It, however, appears to us that although the High Court indicated in the impugned judgment that the defendant's claim of easement right and also the claim of title by way of adverse possession could not be accepted, such weakness in the defendant's title to the suit property cannot establish the plaintiff's title. The High Court has failed to consider the specific finding made by the lower appellate court that the plaintiff had failed to establish the plaintiff's title. It may be noted that the plaintiff was not entitled to get declaration of title if such title could not be established by the plaintiff by leading convincing evidence. The lower appellate court had considered the evidence in detail and by giving cogent reasons had come to the finding that the plaintiff failed to establish the title to the property. Such finding was not reversed by the High Court by indicating any reason for such reversal, but indicating the weakness of the defendant's title, that plaintiff's suit was decreed. Even if it is assumed that the property in question was bequeathed by Bandijan by executing a will, the title of the suit property cannot be declared in favor of the plaintiff unless the title of the executor of will is fully established. In the aforesaid facts, an impugned judgment of High Court cannot be sustained, and the same is therefore set aside, allowing the appeal, the judgment and decree of the lower appellate court restored. Well, 26 married, my lord. Similarly, in AR so-and-so, on consideration of the entire materials evidence on record, it appears that the title and the case of the plaintiff could not be established positively, affirmatively. Mutation of name of a person in the revenue record does not ipso facto create or extinguish the title of the person, nor does it lead to any presumptive value. The revenue record basically entitled the person to pay the land revenue, mere entry in the revenue record does not ipso facto lead to conclusion of the mutation in favor of the plaintiffs, conveys title in their favor. From the ratio of the said decisions, it is clear that a plaintiff in a suit claiming his or her title over suit property must prove her title and the manner how it devolved on the plaintiff. The submission of so-and-so learned senior counsel, that is the defendant's appellant, did not challenge the title of the plaintiff respondent, so there was no duty cast upon the respondent to prove her title, cannot be accepted. If considered in the light of section 101 of the Indian Evidence Act, which specifically cast burden on the plaintiff, that is respondent number 2, to prove her title. So it is not the duty of the defendant, my lord, to challenge the title of the plaintiff, my lord. Next, my lord, it is the same. My lord, this AIR 2001, my next citation is already referred in this case, my lord. AIR 2001,
Yes, yes.
1 it is already
Yes.
referred, my lord. So it is not. Next, my lord, 1998, 9 SCC 719, my lord. It is referred, my lord, sir. Ramdas mentioned. Yes, my lord, Ramdas is also referred, my lord, in this judgment. So Ramdas, I will skip, my lord. Next, my lord, this 1995 3 GLT, my lord, 121. Paragraph 789, my lord. Okay. Married, my lord. In the case of Guru Amarjit Singh, your lordship got it, my lord.
Yes, yes.
In 1995 3 GLT 121.
Yes, I've got it.
Paragraph 7, my lord. In the case of Guru Amarjit Singh, my lord.
Yes, yes.
AIR 1994 so and so, wherein the appellant as plaintiff claimed recovery of possession claiming title on the basis of getting the Jamabandi, the apex court held that the settled law that the entry in the Jamabandi are not proof of title, they are only settlement for revenue purpose. In the case so and so, apex court held that when the suit is based on title, burden of proof the same falls on the plaintiff. Though the court cannot decree a suit merely on the basis of entry in the revenue records. Mr. Chaudhary, learned counsel so and so has fairly considered that in view of the settled law enunciated by the apex court in the series of decision, he is not pressing the claim of the title of the opposite party plaintiff over the suit land, but has submitted that the suit filed by the plaintiff should be treated as a suit based on possession and the terms of the section so and so. Evidence. So, my lord, what this definition, my lord, this findings, my lord, that the burden is on the plaintiff is, my lord, also in relation to, my lord, section 101 of the, my lord, Evidence Act, my lord. So, section 101, my lord, may I read this section, my lord, only for a moment, my lord. Section 101 of the Evidence Act, my lord, is burden of proof. Whoever desires any court to give judgment as to any legal right or liability depend on the existence of facts which he asserts must be that those facts exist. When a person is bound to prove the existence of any fact, it is said that the burden of proof lies on that person. So, my lord, a fact, my lord, a positive fact is always to be proved by the party, my lord. Here the plaintiff, my lord, plaintiff's case is that he is claiming title, that he has the title, my lord. It is not the duty of the defendant to prove that the plaintiff has no title, my lord. The plaintiff has to prove as per section 101 of the Evidence Act because he is claiming title, right title interest. So it is his burden to prove the positive assertion that he has the right title and interest, my lord, about the schedule land. So, my lord, this my lord, Ishwar Das, my lord, 2001 SCC 434. Here, my lord, this judgment is, my lord, that the relevant evidence is not mal considered, my lord. I have shown, my lord, your lordship, that the appellate court, my lord, wrongly, my lord, appreciated the evidence. Paragraph 11, my lord. 11, 11 to both because
Para 11. yes.
11, my lord.
Para 11, yes.
Para 11, because relevant evidence is not considered. There are two situations in which interference with findings of fact is permissible. The first one is when material or relevant evidence is not considered, which if considered would have to lead to an opposite conclusion. The principle has been laid down in a series of judgment, so and so. The court of the first appellate is under a duty to examine the entire relevant evidence on record, and if it refuses to consider important evidence having direct bearing on the disputed issue, and the error which arises is of magnitude that it gives birth to substantial question of law, the High Court is fully authorized to set aside the finding. This is the situation of the present case. In that case, an admission by the defendant tenant in the reply notice in the regard to the plaintiff's title and the description of plaintiffs as owner of the property signed by the defendant were not considered by the first appellate court, while holding that the plaintiff had not proved his title. The High Court interfered with the finding of the ground of non-consideration of the vital evidence, and this court affirmed the said decision that was upheld in so and so. Where the finding by the court of facts is vitiated by non-consideration of relevant evidence or by an essentially erroneous approach of the matter, the High Court is not precluded from recording proper finding. Again, in so and so, it was held that where certain vital documents for deciding the question of possession are ignored, such as compromise and order of revenue court so and so, oral evidence was unjustified in yet another case, so and so. Next, paragraph 12, may read, my lord?
Yes, yes.
11 and 12, 11.
This was paragraph 12 according to my copy what you have given.
My lord,
You have read paragraph 12 according to my copy what you have given.
it is 12. I think, my lord, 11 is sufficient, my lord, regarding the non-consideration of the
Yes.
evidence. So, my lord, regarding, my lord, the oral part of the defendant's, my lord, evidence, my lord, that he could not properly place his case as in the evidence in chief, my lord, may I refer to, my lord, 91, section 91 of the Evidence Act, my lord, provides that the documentary evidence always prevails over the, my lord, oral evidence, my lord. Section 91 of the, my lord, Evidence Act, my lord. So, my lord, 91, my lord, provides, my lord, when the terms of a contract or of a grant or of any other disposition of property have been reduced to the form of a document, that is the sale deed, in this case, or any other deposition of property have been reduced to the form of a document, and all of cases in which any matter is required to be by law to be reduced to the form of document, no evidence shall be given in proof of the terms of the such contract, grant or other deposition of property or such matter except the document itself, or secondary evidence, or is a document in case in which secondary evidence is admissible under the enforcement. So, my lord, this provision of law, my lord, provides that the documentary evidence always prevails over the oral evidence. So, my humble submission is, my lord, both the courts below, my lord, trial court and the, my lord, appellate court, without, my lord, proper appreciation of evidence, my lord, as I have placed the judgments of this court in our apex court, my lord, both the findings are not, my lord, as per law, and that is liable to be, my lord, interfered with by this honorable court, my lord. And this is my humble submission.
Yes.
Okay.
I won't be able to receive any more argument today. Too many arguments today. Some other day?
My lord.
Continue?
Yes, my lord.
Tomorrow?
So, your lordship, may I treat it as a part of my lord.
Tomorrow, day after tomorrow, or after puja?
After puja.
So, what is, this case is lying at which stage? Tell me, then matter, any stay granted or anything?
It stays there, my lord.
Stays
there, my lord.
There is
Execution
execution is stay, my lord.
state,
Execution is stay.
Yes, my lord, and I will take only half an hour, my lord.
Then we will continue tomorrow, day after tomorrow,
Day after tomorrow, my lord.
at 2.
My lord, day after tomorrow, I have some difficulties, my lord. Can it be on my lord 16, my lord, 1/6?
I have no problem, my lord.
Oh,
If your lordship,
huh? 2 p.m. at 2.
my lord,
On 16 at 2 p.m.
my lord,
You'll take only half an hour, no?
half an hour, my lord.
Yes. Please conclude within half an hour then. Otherwise we will have to
I
continue.
will take within half an hour, my lord.
Otherwise we will have to continue till Puja vacation.
Yes.
And then they have, they are enjoying still.
Yes, my lord, yes.
No, my lord, I will take only half an hour.
Huh? মাটি দিবা কৈ দিলে হৈ গ'ল এইটো মাটি দিয়া কাৰোবাক এই ৰেকৰ্ডবোৰ আছে দেই
Obligation.
অ'কে